World Expo 2030, Busan, Korea.
옥상에 주차했어. 창문 열고 피자 배달받고 하이파이브해서 여기 30층인데 우리 집 30층인데 어느새 모든 게 당연해진 나도 오늘은 저 색다른 해 이로써 나는 가는 내 주위에 모두 같은 걸 그렸지 멈춰있는 게 괴로워 머리를 비우고 싶어 Crazy 세상에 없었던 지금 이 순간이 present It's the present 세상에 없었던 새로운 생각이 present
Busan, Korea is already reaching the entire world. Like ocean waves that travel far and wide. It's Busan, the perfect World Expo city. Transforming our world, navigating toward a better future. World Expo 2030, Busan, Korea.
안녕하십니까. 안녕하세요. 잠시 후 글로벌 오션 레진 컨퍼런스 개회식이 개최될 예정입니다. 아직 로비에 계신 분들께서는 장내로 입장하셔 착석해 주시기를 부탁드립니다. Shortly from 9:30 we will have the opening ceremony of the Global Ocean Resin Conference. Participants still at the lobby are cordially requested to come inside and be seated.
올라다녀 우리 집 옥상에 주차했어 창문 열고 피자 배달받고 하이파이브했어 여기 30층인데 우리 집 30층인데
어느새 모든 게 당연해진 나도 오늘은 저 색다른 해 이로써 나는 가는데 종이 위에 모두 같은 걸 그렸지 멈춰있는 게 괴로워 머리를 비우고 싶어 Crazy 세상에 없었던 지금 이 순간
Shortly, we will have the opening ceremony of Global Ocean Raising Conference. Participants still at the lobby are cordially requested to come inside and be seated. 안내 말씀드리겠습니다. 코로나가 다시 확산되고 있어서 현재 거리두기를 준수하여 자리를 배치했습니다. 그리고 유튜브 글로벌 오션 레진 컨퍼런스 채널에서도 저희 컨퍼런스 현장 상황을 보실 수 있습니다. Today's conference is being streamed live through the Global Ocean Raising Conference YouTube channel. 동시 통역 서비스를 제공하고 있으니 한국어는 채널 1번, 영어는 채널 2번에 맞추어 사용해 주시기를 부탁드립니다. We have prepared simultaneous interpretation service during the conference. Please feel free to take a receiver on the desk and turn to the channel 1 for Korean, channel 2 English. Good morning, Your Excellency, distinguished guests, ladies and gentlemen. Welcome to the 2022, the 10th Global Ocean Raising Conference. I'm Kim Ju-hyung from KMI, and it is deeply honored to be here at this meaningful occasions. Well, before beginning, let me extend my sincere gratitude to you for joining us today. This year is all the more meaningful because we are able to invite experts from abroad to Korea after overcoming the COVID pandemic period. This conference is hosted by Ministry of Oceans and Fisheries in cooperation with Korea Maritime Institute. Global Ocean Raising Conference held its first event in 2013 and celebrated its 10th anniversary this year. And to commemorate the 40th anniversary of the adoption of the United Convention on the Law of the Sea, it will be held for 2 days under the theme of UNCLOS at 40 unsettled issues. Now, let us begin the opening ceremony. Dr. Kim Jong-deok, the president of Korea Maritime Institute, will deliver his opening remarks. Please welcome him with a round of applause.
네, 여러분 안녕하십니까? 한국해양수산개발원 원장 김종덕입니다. 제10회 글로벌 오션 레진 컨퍼런스에 참석하신 여러분들을 진심으로 환영합니다. 지난 3년간 코로나 팬데믹으로 인해서 코로나 팬데믹이라는 세계사적으로 유례가 없는 위기를 넘기고 이렇게 직접 얼굴을 뵙고 마주 보면서 회의를 할 수 있게 되어서 더없이 기쁘게 생각합니다. 먼저 오늘 공무로 너무나 바쁘신 중에서도 시간을 내주셔서 오늘 참석해 주신 해양수산부 조성환 장관님께 깊이 감사 말씀드립니다. 그리고 제1회 컨퍼런스부터 지금까지 한결같이 성원과 지원을 아끼지 않으신 박용환 유엔 대륙붕 한계위원회 위원님께도 감사의 말씀을 드립니다. 또 의미 있고 내실 있는 컨퍼런스를 위해서 기조연수를 흔쾌히 허락해 주신 백진현 국제해양법 재판소 재판관님, 블라디미르 야레스 유엔 해양법 국장님과 프레드 순즈 전 중재재판관님을 비롯해 멀리 해외에서 참석해 주신 전문가분들과 발표 토론 사회를 맡아주신 모든 분들께 감사의 말씀을 드립니다. 존경하는 내외 기빈 여러분, 이번 컨퍼런스의 주제는 유엔 해양법 협약 채택 40년 미해결 과제들입니다. 1982년 12월 10일 자메이카 킹스턴에서 채택된 유엔 해양법 협약은 오늘날 바다의 헌법이라고 불리며 국제 해양 질서의 근간을 형성하고 있습니다. 이 협약의 채택은 기존의 해양 질서에 대해 큰 변화를 가져왔습니다. 3해리, 6해리에 불과했던 연안국어 영해가 최대 12해리로 확장되고 최대 200해리의 배타적 경제수역 제도가 새로 도입되고 350해리 이원으로 대륙군 확장이 가능하게 되었습니다. 또한 심해제를 인류 공동유산으로 규정하여 개별 국가들의 영유 경쟁을 막았으며 해양환경의 보호와 보존을 위한 규범의 골격을 마련하고 강제적 분쟁 해결 절차라는 제도를 도입하였습니다. 전통적인 국제해양 질서는 1609년 크로티우스가 자유회론을 주창한 이래 350년 이상 유지되어 오던 좁은 영해와 넓은 공해, 자유로운 해양 이용으로 대표되는 것이었습니다. 유엔 해양법 협약은 이러한 전통적인 해양 질서에 대해 연안국들과 개도국들의 해양에 대한 지배력 확대 요구, 해양환경 보호, 분쟁의 평화적 해결 등 시대 요구들을 적극 수용함으로써 새로운 국제해양 질서의 형성과 유지에 기여하고 있습니다. 한편 이러한 변화로 인해서 유엔 해양법 협약 체제 하에는 해양 경계, 자원 개발, 해상법 집행을 둘러싼 갈등과 분쟁이 크게 증가한 것도 사실입니다. 무엇보다 유엔 해양법 협약이 일괄 타격 방식으로 채택이 되다 보니 많은 조문들이 의도적이든 의도적이지 않든 모호한 상태로 남겨졌으며 이는 결국 국가들 사이의 갈등과 분쟁의 원인이 되고 있습니다. 이번 컨퍼런스의 제1패널과 2패널에서 다루는 해양에 대한 주장 중첩 수역에서의 관할권 행사 문제와 배타적 경제 수역에서의 군사활동 문제가 바로 유엔 해양법상 남겨진 중요한 미해결 과제들입니다. 존경하는 내외 기빈 여러분, 40년 전 유엔 해양법 협약 채택이 해양에 큰 변화를 불러왔듯이 오늘날 해양 질서는 새로운 도전과 변화의 흐름 과정에 있습니다. 글로벌 기후 변화로 인한 위기 현상은 특히 지구 표면의 70%를 차지하고 있는 바다와 연안에서 더욱 심각하게 나타나고 있습니다. 또한 첨단 과학 기술들이 해양에 폭넓게 적용되면서 유엔 해양법 협약 체제 하에서 예상하지 못했던 많은 법적 과제들이 생겨나고 있습니다. 예컨대 장차 도입될 자유로운 선박은 선박의 개념뿐만 아니라 국가의 책임 범위, 민사, 형사, 상사, 해상보험에 이르기까지 해상법 체계 전반에 대한 재검토를 요구하는 사항입니다. 40년 전에 비해 교통통신이 급속도로 발달한 오늘날 국제 해상무역에서는 상호 의존도가 매우 높아서 지구 반대편의 어느 항만의 일시적인 하역 차질이 전 세계 해상물류 시스템 전반에 영향을 끼치는 상황을 맞이하고 있습니다. 이러한 점들에 비추어 이번 컨퍼런스가 지난 40년의 평가에 안주하기보다 유엔 해양법 협약의 미해결 과제를 검토하고 앞으로의 방향을 논의한다는 점에서 의미가 있다고 생각합니다. 이번 컨퍼런스를 통해 유엔 해양법 협약상 난제로 남아있는 문제들에 대해 심도 있는 논의들이 이루어지고 문제 해결을 위한 좋은 의견들이 제시될 수 있기를 바랍니다. 또한 컨퍼런스를 통해서 기후변화와 같은 글로벌 위기 문제 해결을 위한 다양하고 실질적인 방안들이 논의되기를 희망합니다. 존경하는 내외 기빈 여러분, 10년 전 글로벌 오션 레진 컨퍼런스는 국내외 해양법 정책 전문가들이 모여서 공통의 해양 문제에 대해 진지하게 고민하고 의견을 공유할 수 있는 기회를 제공하기 위해서 시작되었습니다. 이 컨퍼런스는 그동안 10개의 다양한 대주제들을 논의하고 100여 명 이상의 전문가들이 참여하면서 국제해양 분야의 중요한 학술 교류의 장으로 자리매김하고 있습니다. 이번 컨퍼런스에서는 이를 한 단계 더 발전시켜 신진 학자들의 연구 발표 기회를 별도로 마련하였습니다. 또한 한국해양수산개발원은 해양수산부와 협력하여 국내외 젊은 해양법 전문가들의 양성에 힘을 쏟고 있습니다. 최근에는 대한민국 국회에서도 관련법을 개정하여 해양법 전문 인력 양성을 제도적으로 지원하는 데 힘을 보태주시고 계십니다. 아무쪼록 글로벌 오션 레진 컨퍼런스가 해양을 연구하는 신진 학자들의 등용문이 되고 기성학자들의 학술 교류의 장이 될 수 있기를 진심으로 희망합니다. 나아가 이 컨퍼런스를 통해서 유엔 해양법 협약상의 많은 난제들을 해결하기 위한 단초들이 제시될 수 있기를 기대합니다. 마지막으로 외국에서 오신 모든 내 귀빈 여러분, 서울에 머무는 동안 건강하게 또 즐거운 시간 보내시기를 기원합니다. 감사합니다.
Thank you. Next is welcoming remarks from His Excellency Mr. Jo Seung-hwan, Minister of Oceans and Fisheries. Ladies and gentlemen, let's give a warm welcome to him to the stage.
예, 우리 교수님들 정말 반갑습니다. 해양수산부 장관 이전에 저도 이 과거에 해양법을 공부하던 사람으로서 존경하는 우리 국내외 선배님들 이렇게 뵙게 돼서 너무나 반갑고 항상 감사하다는 말씀, 우리 해양에 대해서 연구해 주시고 또 정리해 주시고 해서 항상 감사하다는 말씀 먼저 드리고 싶습니다. 제10회 글로벌 오션 레짐 컨퍼런스 개최를 진심으로 축하드립니다. 코로나 팬데믹으로 인해서 3년 동안 개최되지 온라인으로만 개최되다가 이렇게 직접 여러분들 얼굴을 뵙게 되니 더더욱 반갑고 기쁩니다. 연말이라 더없이 바쁜 시기에도 불구하고 오늘 유엔 해양법 협약상의 미해결 과제들이란 주제에 대해 함께 논의하고 해법을 찾기 위해 찾아주신 국내외 전문가 여러분들을 진심으로 환영합니다. 컨퍼런스의 성공적 개최를 위해서 온갖 지원과 성원을 아끼지 않으시는 우리 김성진 전 해양수산부 장관님 조금 늦으시는 것 같습니다. 또 우리 박용환 우리 대륙붕 한계위원회 위원님, 또 우리 김종덕 해양수산개발원 원장님과 우리 관계자 여러분들께 진심으로 감사를 드립니다. 또 우리 유엔 해양법 협약 채택 40년 미해결 과제로서 배타적 경제 수역 문제라는 주제로 우리 기조 연설을 맡아주신 우리 백진현 국제해양법 재판소 재판관님, 그리고 알프레드 순스 전 중재재판관님, 브래드미러 야레스 유엔 해양법 국장님, 닐루프 오랄 국립 싱가포르 대학 교수님을 비롯한 발표자와 토론자 여러분께도 감사의 말씀을 드립니다. 올해는 바다의 헌법이라 불리는 유엔 해양법 협약이 채택된 지 40년 되는 의미 있는 해입니다. 1982년 12월 10일 자메이카 몬데고 회의에서 채택된 유엔 해양법 협약은 현재 유엔 회원국 193개국 중 168개 국가가 비준하여 전 세계가 준수하는 해양 규범으로 자리 잡고 있습니다. 지난 40년간 많은 연안국들이 더 넓은 바다를 차지하기 위해 관할권을 경쟁적으로 확대하는 가운데 유엔 해양법 협약은 국제 이용의 원칙과 기준을 제공함으로써 평화적인 국제 해양 질서 유지에 기여해 왔습니다. 이러한 국제 해양 질서 유지에 기여함에도 불구하고 여전히 풀어야 할 과제들을 또 안고 있는 것도 사실입니다. 무엇보다 320개 조문과 8개 부속서로 구성된 방대한 내용의 협약이 국가 간의 이해관계로 채택 과정에서 많은 조문 내용들이 불분명하게 남겨졌고 과학기술이 발달하면서 채택 당시 예상하지 못했던 사안들이 새롭게 등장하고 있기 때문이라고 생각합니다. 이런 점에서 유엔 해양법 협약 채택 40년의 공과를 냉정하게 평가하고 협약상 미해결 과제를 논의함으로써 협약의 발전 방향을 탐구하는 이번 컨퍼런스는 매우 의미 있다고 생각합니다. 이번 컨퍼런스에서 발표하게 될 해양 경계 미확정 수역에서의 관할권 문제와 연안국 이지 내 외국의 군사활동 문제는 국가 간의 갈등과 긴장을 촉발하는 매우 어려운 주제입니다. 또한 기후변화로 인한 해수면 상승과 해양법 문제는 위기에 처한 국가들뿐만 아니라 국제사회 전체가 경각심을 가지고 함께 풀어 나가야 할 과제이기도 합니다. 짧은 기간이지만 이번 컨퍼런스에서 세계적인 석강 여러분들을 통해 국제해양법 문제들에 대한 인식을 새롭게 하고 해결의 실마리가 제시될 수 있기를 기대해 봅니다. 특히 국제해양법 분야의 신진 연구자들을 위한 자리가 마련되어 매우 뜻깊게 생각합니다. 국제해양법 학계의 미래 주역들이 연구한 주제를 발표하고 선배 전문가 여러분들과의 의견을 개진하면서 개인의 학문의 발전하는 계기로 삼으시고 나아가 세계가 상호 협력할 수 있는 해양 질서의 새로운 이론이 만들어지는 자리가 되었으면 합니다. 저희 해양수산부는 한국의 해양법 전문가 양성뿐 아니라 여수해양법 아카데미 등을 통하여 세계의 젊은이들이 해양법 전문가로 성장할 수 있도록 기여하고 있습니다. 아울러 한국 정부는 2030 부산 세계박람회를 세계적인 해양도시 부산 제 고향이기도 합니다. 유치하기 위해 노력하고 있습니다. 바라건대 오늘 이 자리에 참석하신 여러분들의 많은 관심과 지원 부탁드립니다. 끝으로 한국에 머무시는 동안 좋은 추억들 많이 만들어 가시기를 바라고 참석하신 분들의 건강과 행복을 기원합니다. 감사합니다.
Thank you. And now, ladies and gentlemen, it is great pleasure to invite our keynote speaker, the Judge Baek Jin-hyun of International Tribunal for the Law of the Sea. Please welcome him with a big round of applause.
Good morning, Minister Cho, President Kim, and dear colleagues. I'm honored to deliver a keynote speech in 2022 Global Ocean Regime Conference. I would like to thank the organizer of the conference, Ministry of Oceans and Fisheries, and Korea Maritime Institute for their kind invitation. I also want to congratulate them for putting together an excellent program which includes many interesting topics. This year marks the 40th anniversary of the adoption of United Nations Convention on the Law of the Sea. Naturally, throughout the year, there have been numerous conferences and occasions to celebrate one of the most significant achievements of international community in public international law. I'm sure that many of you have attended at least some of those occasions. Now, as 2022 approaches to the end, this conference may be one of the last occasions, if not the last, to celebrate the adoption of the convention. For that matter, I find it quite appropriate that today's conference chose the question of unsettled issues of UNCLOS as its theme. Certainly, this is the subject we need to pause to reflect on at the end of celebration of UNCLOS. Today, I want to address the regime of exclusive economic zone in this context. Few would deny that the exclusive economic zone was one of the most important achievements of UNCLOS. Today, this zone constitutes one of the main pillars upholding the global ocean regime underpinned by UNCLOS. The exclusive economic zone was a bold, innovative, and I would say even revolutionary notion. It fundamentally changed the legal order of the ocean, which had existed for centuries, namely the freedom of the sea with exception for a narrow belt of the territorial sea subject to the sovereignty of the coastal state. The extension of the exclusive coastal state jurisdiction beyond the territorial sea was a radical departure from the traditional order of the sea. As such, it required unprecedented rebalancing of diverse and often conflicting interests of many states. As a legal doctrine, the exclusive economic zone also introduced many innovative notions such as functional zone, sui generis regime, and sovereign rights. However, it should be noted that the exclusive economic zone was not entirely a product of UNCLOS. On the contrary, the genesis of this zone may be traced back to a few decades before the convening of the Third UN Conference on the Law of the Sea. Since the Truman Proclamations of 1945, which were the first clear enunciation of the national policy to claim resources in the area beyond the territorial sea, a series of unilateral claims to the maritime spaces, including both waters and the seabed and subsoil, followed in the 1940s and 50s. While the initial proclamation made by the United States had been drafted carefully and rather modest in terms of what it claimed, many subsequent claims were not necessarily so in their geographical and substantive scopes. The failure of the two United Nations Conference on the Law of the Sea to fix the breadth of territorial sea and to accommodate the concern of the coastal state as to the conservation and exploitation of living resources in the adjacent sea beyond the territorial sea further accelerated this trend in the 1960s. As a consequence, by the time the third UN Conference on the Law of the Sea was convened, the concept of extended coastal state jurisdiction beyond the territorial sea gained rapid ground among a growing number of states. Among various claims and proclamations made in this regard, I may draw your attention to Santo Domingo Declaration of 1972, made by 16 Caribbean states, which introduced the concept of patrimonial sea. You would be struck by a close similarity between the text of this declaration and Part 5 of UNCLOS. Indeed, the concept of EEZ and the broad allocation of rights and duties between the coastal state and other states in the zone were already there in the notion of patrimonial sea, which was neither territorial sea nor the high seas. So it was no surprise that when the first negotiating text of the conference, informal single negotiating text, ISNT, was issued towards the end of the third session in 1975, the concept of EEZ was already widely accepted among negotiating states. Indeed, by 1975, the extension of exclusive coastal state jurisdiction over resources beyond the territorial sea was a foregone conclusion. However, this does not mean that the negotiation over the exclusive economic zone was over. While the broad outline of the regime of the exclusive economic zone was accepted, the legal status of the EEZ, together with the related question of residual rights, remained unresolved and highly contentious. The intense tug of war has continued, therefore, between maritime states which insisted on preserving the exclusive economic zone as a part of the high sea, and coastal states group which could not accept the new zone being anything other than a sui generis regime, neither residual territorial sea nor residual high sea. There were two main contentious issues in this respect, namely the formulation of wordings for the rights and duties of other states in the exclusive economic zone and the definition of the high sea. For the first issue, maritime states consider the formulation, I quote, other internationally lawful uses of the sea relating to navigation and communication, end of quote, contained in the ISNT too restrictive. While they preferred other lawful use of the sea without any qualification, such formulation was simply unacceptable to many coastal states. For the second issue, that is definition of the high sea, the relevant provision in the ISNT defined the high sea as, I quote, all parts of the sea that are not included in the exclusive economic zone, in the territorial sea, or in the internal waters of state, or in the archipelagic waters of an archipelagic state, end of quote. Maritime states were concerned with the explicit exclusion of the exclusive economic zone from the definition of the high sea and its implication for the legal status of the exclusive economic zone and the question of residual rights. For them, such definition would make it clear that exclusive economic zone is not part of the high seas. Eventually, the question of the legal status of EEZ and residual rights were resolved in the following ways. First, as regards the legal status of the exclusive economic zone, a new provision which reaffirmed the sui generis nature of the EEZ in clear terms was added. This provision has become Article 55 of UNCLOS. I'm sure you are familiar with this provision. Second, maritime powers' misgivings concerning the restrictive character of the phrase other internationally lawful uses of the sea related to navigation and communication were addressed by replacing it with a new formulation which reads, I quote, other internationally lawful uses of the sea related to these freedoms, such as those associated with the operation of ships, aircrafts, and submarine cables and pipelines, and compatible with the other provision of this convention, end of quote. However, it is far from clear whether this new lengthy formulation would necessarily entail the wider scope of the rights for other states in the exclusive economic zone. Third, a provision on the definition of the high sea was redrafted to accommodate the concern of maritime powers. Instead of defining the high seas, this new provision was reformulated to indicate the geographical scope for application of the provision of the high seas. In addition, a new sentence was added to make sure that, I quote, this article does not entail any abridgment of the freedom enjoyed by all states in the exclusive economic zone in accordance with Article 58. Of course, this provision has become Article 86 of the UNCLOS. With these new additions and modification, a broad balance of interests as to the legal status of exclusive economic zone and residual rights therein was achieved. This is how Articles 55, 56, 58, and 59 of the Convention came about. This legislative history shows that the EEZ is one of the classical examples of the emerging state practice being crystallized and elaborated by a multilateral treaty-making process. It also shows that behind the complex and carefully devised compromise lay some outstanding and potential differences. While the regime of the exclusive economic zone is firmly established in international law, this does not mean that the EEZ is a zone free of controversies or disputes. On the contrary, many disputes and conflicts arise over the use of the exclusive economic zone. In fact, among different maritime zones, the EEZ has been the most dispute-prone zone. For example, a large majority of disputes that have been submitted to international courts and tribunals are directly or indirectly related to activities carried out in the exclusive economic zone. Thus, the EEZ can be described as a zone of tension in which another round of competition between the coastal state and other states continues, this time, of course, within the framework of UNCLOS. Tension over the EEZ came from several sources. Let me elaborate. First, there is an inherent tension arising from the concurrent or competing uses of the same maritime zone. The EEZ is a zone in which the rights and duties of the coastal state coexist with those of other states. When the same zone is used by multiple states with competing rights without any hierarchy or priority, disputes and conflicts may be unavoidable. Participating states at UNCLOS' third conference on the law of sea were not unaware of such inherent tension. Thus, UNCLOS provides for a priority of one set of rights over another set of rights in certain situations. For example, Article 60 paragraph 7 of the convention gives a priority to the right of other states to use recognized sea lanes essential for international navigation over the right of the coastal state to establish the safety zone around artificial islands, installation, and structures. Article 79, paragraph 2 provides that the coastal states' rights relating to resource exploration and exploitation and the protection of the marine environment, as long as they are reasonable, prevail over the freedom of other states to lay submarine cables and pipelines. Likewise, Article 79, paragraph 3 provides that the delineation of the course for the laying of pipeline on the continental shelf is subject to the consent of the coastal state. Of course, the most important mechanism to address the situation of conflicting rights is the mutual or reciprocal duties of due regard provided for in Article 56, paragraph 2 and 58, paragraph 3. Indeed, these duties arise from the recognition of the need for accommodation of competing uses of the exclusive economic zone. The elusive notion of due regard has been clarified to some extent by international courts and tribunals in some previous cases. While the duty of due regard by nature may not be defined in general or in the abstract, it is recognized that this duty entails substantive and procedural obligations. It entails procedural obligations such as notification, consultation, and exchange of views. It may also require states concerned to take account of each other's rights and duties and the mutual balancing of those rights and duties. Another cause of tension in the exclusive economic zone arises from the tendency of the coastal states to expand its competence in the exclusive economic zone, apparently beyond what is provided for in the convention, in order to protect its resource, environmental, or security interests. This tendency is often characterized as territorialization of the exclusive economic zone. For example, some coastal states require foreign fishing vessels to notify them before those vessels transit their exclusive economic zone. While such requirement may be imposed to protect living resources of the coastal state, it may result in the interference with the freedom of navigation other states are entitled to in the exclusive economic zone. Perhaps the most serious problem in this regard arises from the clash between environmental jurisdiction of the coastal state and freedom of navigation of other states. Some coastal states impose a strict safety regulation on foreign ships carrying dangerous cargoes. In particular, they require prior authorization or even prohibit entirely the passage of ships carrying hazardous radioactive materials. However, anti-pollution laws and regulation of the coastal states in respect of EEZ must conform to and give effect to generally accepted international rules and standards. While the coastal state may adopt more stringent rules and standards under certain circumstances, such rules and standards still have to meet the substantive and procedural requirements provided for in the Convention. Thus, the measure taken by some coastal states in this respect appear to be problematic. Territorialization of the exclusive economic zone was not totally unexpected, given that sovereign rights are interpreted broadly to include, I quote, all rights necessarily for and connected with exploring and exploiting, conserving and managing the natural resources, end of quotation. Furthermore, sovereign rights extend to other activities for the economic exploitation and exploration of the zone. Such broad and almost open-ended nature of sovereign rights may give the coastal state some flexibility in the exercise of its competence in the exclusive economic zone. However, it is clear that there is a limit or boundary to the scope of sovereign rights of the coastal states. Clarification of such limits through state practice, international agreements, or judicial decision of international courts and tribunals would be helpful in reducing tension in this regard. The third source of tension is related to issues which were not sufficiently addressed or intentionally averted at the conference. Military activities in the EEZ may be one of such issues. As you may know, several disputes and conflicts have erupted over military activities in the exclusive economic zone, especially in this part of the world. Military activities were not the item of negotiation among participating states at the conference. The convention contains no explicit provision on this matter other than Article 88 on reservation of the high seas for peaceful purposes, which applies to exclusive economic zone as well pursuant to Article 58, paragraph 2, and Article 301 on peaceful uses of the sea. However, this does not mean that such matter was outside the concern of negotiating states. On the contrary, the unimpeded military and strategic uses of the EEZ was one of the priority concerns for naval powers. However, they wanted to achieve their objective not by addressing this issue directly, but rather by making the exclusive economic zone as a zone akin to the high seas as much as possible. Maritime states and naval powers seem to be of the view that the provisions of the convention, in particular the formulation in Article 58, confer upon them the right to conduct military activities in the exclusive economic zone of the coastal state. Such view was well reflected in the comment made by United States at the conference. I quote, Article 58 of the Convention preserves for the international community, in addition to certain specified high sea freedoms, all other high sea freedoms traditionally enjoyed by the ships and aircraft which are recognized by general principles of international law. End of quotation. I already reviewed the negotiating history relating to the legal status of exclusive economic zone, including the formulation of freedoms and rights enjoyed by other states in the exclusive economic zone. I'm just wondering whether the text of Article 58 or its legislative history can justify such a view. I'm aware that there is a session devoted to this issue in the afternoon. Therefore, I will refrain from going further. The fourth and final cause of tension may be related to the new uses of the exclusive economic zone. As science and technology advance, there is likely to be an increasing number of new uses of the exclusive economic zone. I already mentioned the almost open-ended nature of sovereign rights of coastal states. It is therefore not difficult to expect that the coastal state may exercise its competence over the new uses of the EEZ on the basis of sovereign rights. Alternatively, it could be argued that many new uses may fall to the category of residual or unattributed rights. However, a mechanism to resolve conflicts over such residual rights provided for in Article 59 of the Convention appears to be ambiguous. In concluding, for almost half a century after its introduction, the exclusive economic zone has settled down as an institution, but it remains a zone of tension. While the exclusive economic zone has been able to stop the trend of the expansion of national maritime jurisdiction, which is without any doubt a great achievement, a delicate balance achieved in the convention is challenged by various sources. In a sense, a new version of the competition between mare liberum and mare clausum is now taking place over the scope of rights of the coastal state and that of other states. In the meantime, some deficiency or gaps of the EEZ regime under the convention have been filled by post-UNCLOS instruments such as UN Fish Stocks Agreement and Underwater Heritage Convention. Several ambiguous notions such as that of due regard or sovereign rights, conservation and management have also been clarified to some extent through the decisions of international courts and tribunals. However, there are scores of other questions that need to be answered. Furthermore, as the uses of the sea will expand and the new uses of the sea, which has so far not been contemplated, emerge with the technological advance, new category of disputes and conflicts will likely arise. For this reason, I believe that the exclusive economic zone will continue to remain a zone of tension for years to come. This brings me to the end of my speech. I'm now looking forward to 2 days of very promising presentation on a number of highly interesting topics in the law of the sea and productive and enriching discussions. Thank you very much for your attention.
Thank you. Now we will have a group photo session. Distinguished guests, presenters, and discussants, and ladies and gentlemen, please join in the photo session. Thank you. 여러분 앞으로 좀 나와주시면 감사하겠습니다. Please come up to the stage for the photo. After taking a photo, we will have a short break for setting up the stage. 예, 좀 나와 주십시오. 연구진들 올라오세요.
네, 다 나오세요.
연구진 올라오세요.
네, 다 나와. 네, 다 같이 찍어요.
That completes the opening ceremony for the 2022 Global Ocean Raging Conference. Thank you very much. We will continue the next program after a short break for setting up the stage. We will resume the conference at 10:30, 10:30. Thank you.
아.
The presentations are they 15 minutes, 20 minutes, or what's the limit?
15 to 20.
15 to 20?
Actually 20.
Yeah. Yeah.
Short is better.
Yeah. Some of that. I just attended a conference in Hamburg Friday, Saturday last week. Actually, there were just 2 speakers, each panel, which left room for 30, 35, 40 minutes, Q&As. Many questions that can be addressed, but there's a shortage of time. It's always like that.
As a moderator, I want to ample time to audience to take some questions.
You ready? Well, yes, it is. I think all of us. Tire myself, but in vain.
아직 진행 중이죠.
내가 자료를 좀 주려고 생각하고 있었는데 언제 시간이 되고 한번 자료가 좀 많아요. 저렇게 정리하는 거 모아놓은 거 있으니까 그걸 통째로 주려고. 지금 청구가 많이 됐고요. 진짜 웰 관련해서.
뭐 서울에 장모님 할까요?
네. 그래서 조만간에 한번 하시려고 제가 등록하면 되니까 이만큼 좀 청구 많이 돼요. 비밀도 있고 그래가지고.
네.
저기 이제 조만간 한번 하지 뭐. 추정 한번 오시면 되지.
네. 딱 연내는 좀 힘들 것 같고.
그러니까 연초에 한번 해가지고 하고 점심 먹고 가면 되니까 11시쯤 일어나면
감사합니다. 저 이제 세션 준비할까요?
틀어주세요.
저 민영권님 밖에 좀 들어오시라고 좀 해주세요. Now we are going to commence session 1. Participants still at the lobby are cordially requested to come inside and be seated. 회의장 외부에 계신 참석자분들께서는 장내로 이동 부탁드립니다. participants at the lobby are cordially requested to come inside. 내 목소리는 밖에 안 들리고. 그러게요. 이 토론자분도 안 오셨네.
So my presentation will be messed up.
토론자 발표자분들께서는 단상으로 올라가 주시기 바랍니다. Professor Sunil Agrawal, please come up to the 최진영 교수님, 시작할까요? 최진영 교수님 괜찮아요? Okay. Now we are going to commence session 1. This session will be discussing about the exercise of jurisdiction in the area of overlapping maritime claims. Moderator of this session is Dr. Kim Hyun-soo, professor of Ina University Law School. Now I will turn the session over to him.
Thank you, Jill. Good morning again. I will start session 1 as a moderator. I will just announce some particular things. We have 3 distinguished panels. So please, each presenter have just 15 to 20 minutes for your presentation. Please keep the time limit. We have quite tight schedule this morning. Please remember that. And after that, after completion of the whole presentation, we will have some discussion time, depending on your chair's time schedule. So maybe 5 to 10 minutes, yes. Yes, the topic of this session is exercise of jurisdiction in the area of overlapping maritime claims. UNCLOS was already concluded and currently effective, but still it causes a lot of ocean matters, so particularly maritime boundary delimitation in the EEZ. So as a result, it may also occur so many ocean issues, particularly in an area where the distance between states is less than 400 miles. Still, we have a lot of things to do. Still, because the even we may solve the problems in terms of agreements or jurisprudence, but still we are not enough yet. So today we'll touch upon such crucial issues, how to solve the problems occurred in the overlapping claim zones and undelimited areas. So today's first speaker, I would like to introduce and invite Professor Kentaro Nishimoto from Tohoku University, and he'll present a paper titled "The Obligation of Self-Restraint in Undelimited Maritime Areas: Content, Utility, and Limitations." Please warm welcome Professor Kentaro. You have the floor, please.
Good morning. Before I begin my presentation, I would like to express my great gratitude to the Ministry of Oceans and Fisheries and the Korea Maritime Institution for the invitation to speak at this conference among the distinguished line of experts in the law of the sea. So the topic for my session is the exercise of jurisdiction in the area of overlapping maritime claims. And in my presentation, I would like to focus on one of the two obligations contained in Articles 74.3 and 83.3 of UNCLOS, which is the obligation of states during the transitional period to make every effort not to jeopardize or hamper the reaching of the final agreement. And I would like to refer to this obligation as the obligation of self-restraint, although this term is not used in the provision itself, simply as a shorthand for describing the obligation, because to say obligation not to jeopardize or hamper the reaching of the final agreement every time is quite a mouthful. So the importance of this obligation in the East Asian context and also in other areas of the world probably do not need to be explained in detail here. For example, in the East China Sea, we do have overlapping claims between China, Japan, and South Korea. And for example, to take the situation of Japan in its relations with China, Japan has raised issues with the unilateral hydrocarbon development activities that are being conducted by China in the East China Sea. On the slide are some information from the website of the Ministry of Foreign Affairs of Japan. And while the Chinese activities are currently being conducted on the Chinese side of the median line or the equidistance line, the government of Japan has stated, as highlighted on the slide in blue, it is extremely regrettable that China is advancing unilateral development even on the Chinese side of the geographic equidistance line. And while this statement is not phrased as an argument based on Article 83.3, of course, this kind of situation raises the question of what is the precise scope of the obligation of self-restraint. So the purpose of my presentation is to consider the scope of the obligation as one of the unsettled issues regarding UNCLOS, which I understand to be the overall theme for this conference. And in doing so, I would like to consider the scope of the obligation of self-restraint and how their violations have in particular been determined in the jurisprudence of international courts and tribunals. And I would like to also add to this some consideration of the impact of the current state of the law on coastal states with undelimited maritime areas, and also an examination of the possibility of further clarification of the scope of the obligation by resorting to the dispute settlement procedure of UNCLOS. So the first international case to deal with this issue was Guyana versus Suriname, which was a maritime boundary delimitation case in an Annex 7 arbitral tribunal. In this case, both parties to the dispute claimed that the other side had violated the obligation of self-restraint, and therefore the tribunal was required to consider what kind of activities could be conducted in undelimited maritime areas. The starting point for the tribunal was that was something that which can be confirmed from drafting history, that the obligation of self-restraint was not intended to prohibit all activities in undelimited maritime areas. And so in this regard, the award states, as shown on the slide, that there are two classes of permissible activities. One is activities undertaken by parties pursuant to provisional arrangements. The other is acts which, although unilateral, would not have the effect of jeopardizing or hampering the reaching of the final agreement on the delimitation of the maritime boundary. And in identifying which acts would fall under the two classes, the tribunal stated in paragraph 467, as shown on the slide, that unilateral acts which do not cause a permanent physical change to the marine environment would generally fall into the second class, which means that they will be considered as permissible. And, but according to the award, acts that do cause physical change would have to be undertaken pursuant to an agreement between the parties to be permissible, as they have the effect of jeopardizing or hampering the reaching of the final agreement on delimitation. And the tribunal justified this distinction as being consistent with the jurisprudence on interim measures.
So in this way, Guyana v. Suriname introduced the criterion of physical change, or in other parts of the award, permanent physical change to the marine environment. However, I think it is important to recognize that although, according to the tribunal, activities that cause permanent physical change are always inconsistent with the obligation of self-restraint, activities that do not are not always permissible. For example, when we look at a specific conclusion reached in paragraph 481 of the award, which is again reproduced on the slide, the tribunal did mention in general terms that seismic activity, on the other hand, should be permissible. This is presumably because they do not cause physical change. However, if we look into the more details of what is stated in this paragraph, the paragraph continues by noting that activities in question did not give rise to objections from the either side. And after noting this, the tribunal concluded that in the circumstances at hand, the tribunal does not consider seismic testing is inconsistent with the obligation of self-restraint. So this can be read as not necessarily a categorical determination, but as something based on the circumstances at hand, implying a case-by-case approach. The next case dealing with the judgment, dealing with this issue, was the judgment by the Special Chamber of ITLOS in the Ghana-Cote d'Ivoire case. This was also a maritime boundary delimitation case in which a decision on responsibility for actions prior to the delimitation was also requested. One issue in this case was that Ghana had continued its hydrocarbon development activities, of course, including drilling, even after realizing that the area was also claimed by Cote d'Ivoire. And Cote d'Ivoire argued in this case that this was a contravention of Article 83.3. However, the Special Chamber considered that Ghana did not violate the obligation of self-restraint and gave two reasons, which are further addressed in the next slide. So the first reason was that Ghana, in the end, suspended its activities by implementing its obligations under the Provisional Measures Order that was issued by the Special Chamber in this proceeding. The order had required Ghana that no new drilling would take place in the disputed area. The second reason was, in short, that Cote d'Ivoire had requested the Chamber to declare and adjudge that the activities undertaken unilaterally by Ghana in the Ivorian maritime area constituted a violation. However, as a result of the judgment on maritime delimitation, it was found to be the case that activities had only been conducted on the Ghana side of the equidistance line. So, so that was the first reason. The second reason, sorry. The second reason can be understood as the application of the non-ultra petita rule, namely that a court cannot decide more than it is asked to do. And since Cote d'Ivoire only claimed a violation in the Ivorian maritime area and not for the entire area before it was delimited, and since Ghana did not undertake any activities on the resulting Ivorian area as a result of the delimitation, the Chamber could only respond that Cote d'Ivoire submissions cannot be upheld. This would have likely been sufficient in terms of dismissing the submission of Cote d'Ivoire, but the Chamber had another reason to add, which was no new drilling. This reason is an indication that the approach adopted by the Special Chamber is at least in some way inconsistent with the approach adopted in the previous case, which was Guyana versus Suriname. And this is because, according to the approach adopted in Guyana versus Suriname, the fact that drilling was conducted would violate the obligation even if no new drilling was undertaken. The approach adopted by the Special Chamber was criticized by Judge Peck in his separate opinion, who raised a serious reservation about the lawfulness of Ghana's activities in the disputed area under Article 83.3. On the question of what actions would jeopardize or hamper the reaching of the final agreement, the separate opinion suggests that Article 83.3 reflects a result-oriented notion, and the right question to ask here is not necessarily the type of the activity as being definitive, but whether the action would have the effect of endangering the process of the reaching of the final agreement. the separate opinion also suggested that several factors may be considered, in particular the type, the nature, location, time of acts, as well as the manner in which they are carried out. However, there is no single test or criterion, and the relevant factors must be taken into account and balanced in the framework of the relations between the states concerned. So in this way, the judgment in Ghana, Cote d'Ivoire raised questions regarding the appropriate criterion and approach in deciding whether a certain act violates the obligation of self-restraint. Then came another case before the International Court of Justice, which was Somalia v. Kenya. This was another maritime delimitation case before the International Court of Justice this time. The discussion of the issue by the ICJ is very short, but I would say full of implications. In paragraph 207 of the judgment, again shown on the slide, the court considered Somalia's arguments that certain activities, such as the performance of surveys, violated the obligation of self-restraint. And as highlighted in yellow on the slide, on this point, the ICJ stated that these activities are not the kind that could lead to a permanent physical change in the marine environment, and it has not been established that they had the effect of jeopardizing or hampering the reaching of a final agreement on the delimitation of the maritime boundary. This can be considered as closely following the approach adopted in Guyana versus Suriname. One very obvious aspect, of course, is that the criterion of permanent physical change was adopted by the ICJ. However, I think it is also very important that the ICJ considered whether activities not causing permanent physical change had the effect of jeopardizing or hampering. This is quite consistent with the understanding in Guyana versus Suriname, which stated that unilateral acts which do not cause a physical change would generally be permissible. And also in that case, the tribunal reached a conclusion based on the circumstances at hand. The position adopted by the ICJ in this case appears also to embrace Judge Peck's result-oriented notion and focuses on particular circumstances. The term effect also was used in the separate opinion, and this term is also used by the ICJ in this paragraph. So although Ghana and Cote d'Ivoire created some problems regarding how to consistently understand the jurisprudence of international courts and tribunals on this issue, there appears to be a trend, at least in a certain direction, based on Ghana versus Suriname and Somalia versus Kenya. And although I don't want to oversimplify the issue, and I always tell my students not to rely on these kind of diagrams, I sort of tried to provide a framework as in the form of a diagram. So the ICJ did not give particular weight, did also give a specific weight to the issue of permanent physical change. But even in cases where there is no permanent physical change, there still may be a violation of the obligation of self-restraint. However, up to now, there are no examples of cases where activities that are not causing permanent physical change were found to be a violation. So this case-by-case analysis on the right hand, which is shown as a kind of a black box, we do not really know what would go into that balancing in the area of the black box. And to use the wording of the ICJ, I think the idea is to look for whether there was an effect of jeopardizing or hampering, but how this would be conducted is still unclear as a matter of actual precedent. However, it is of course possible perhaps to refer to the factors you raised in Judge Peck's separate opinion, and so to balance the factors for the considerations that will be done in the part indicated as the black box. So based on the cases, I think we can see at least that the jurisprudence of international courts and tribunals have contributed to the clarification of the unilateral activities that are permissible under the obligation of self-restraint. Although there is the question of how to consistently understand or distinguish Ghana, Cote d'Ivoire, the non-permissibility of activities causing permanent physical change, I think, is attracting at least support. although we have to take into account the fact that cases so far are limited to hydrocarbon activities, and there may be a way of distinguishing the case law if we are arguing a different type of an activity. And also a certain framework for determining violations of the rule could perhaps be considered as emerging through the case law. On the other hand, the content of the obligation for activities not causing permanent physical change, of course, is not very clear. And although the case-by-case approach may be the most appropriate way to approach this issue from the perspective of courts, this may be unsatisfactory for coastal states looking for more specific norms of conduct that can guide their relations in undelimited maritime areas. And in this regard, the accumulation of further cases may contribute to a better understanding of the content of the obligation. And given the perhaps tendency in recent years for this issue to be raised in maritime boundary delimitation cases, we might be seeing further cases in the future. But in relation to this, before concluding, I would like to address one more issue, which is the issue of whether a state can refer a dispute concerning compliance with this obligation to compulsory procedures under the UNCLOS dispute settlement procedure. An obvious jurisdictional hurdle is, of course, the article that we have on the slide, Article 298, which allows states to opt out of compulsory procedures for disputes concerning the interpretation or application of Articles 1574 and 83 relating to sea boundary delimitations. This limitation is particularly relevant in East Asia, where China, South Korea, and Russia have all made declarations under all of the items listed in Article 298. On this issue, the Conciliation Committee in the Timor Sea Conciliation, whose competence was to address disputes that were removed from the compulsory procedures, specifically under Article 298, decided that it was competent to decide, in addition to the actual delimitation of the boundary, issues relating to the transitional period. If this understanding was the correct one, this could imply that disputes concerning the obligation of self-restraint cannot be brought to compulsory procedures because they are removed from compulsory jurisdiction due to this article. However, there are some issues relating to the interpretation of this article, such as whether the clause relating to sea boundary delimitations simply describes Articles 1574-83 or is intended to limit the exception to certain types of disputes concerning the articles. And although the Conciliation Commission focused on Articles 74-83, leading to the conclusion that these articles do not only address the actual delimitation process, I think there is the question of how to read relating to sea boundary delimitations, and the fact that the drafting history suggests that the purpose of the provision was to remove politically sensitive disputes from compulsory procedures. This rationale may not equally apply to the actual delimitation and the obligation of self-restraint. In addition, in this case, what was at issue was the transitional arrangements associated with the delimitation of the actual maritime boundary, and perhaps the case could be distinguished from the issue of not jeopardizing or hampering in the transitional period. Therefore, there seems to be at least a possibility of requesting a direct finding on the scope of the obligation using Part 15, which may contribute to further clarification of the scope of the obligation in the future. And with that, I would like to conclude my presentation. Thank you very much for your attention.
Thank you, Professor Kentaro. He just pointed out some what are legal activities in undelimited areas or overlapping claim zone. So in terms of international rule of law, so still there's so many loopholes, and we cannot easily to define what are legal activities in overlapping areas. So he just explained, he introduced two cases, Guyana, Suriname, and Cote d'Ivoire and Ghana. So it was quite useful. So still we are wondering how to define where the activities causing permanent physical change to maritime environment. permissible or not. Still, we have some doubts on that. And so, I would like to move on to next speaker. I would like to invite next speaker is Sunil Kumar Agarwal, visiting faculty, Indian Society of International Law. He will present a paper titled "Exercising the Coastal State Jurisdiction for the Repression of Piracy on the UNCLOS from an Indian Perspective." Dr. Sunil, please, you have the floor.
Thank you, Professor. Let me take this opportunity to express my gratitude to the KMI, Dr. Park, for giving me this opportunity to presentation before this August audience. The title of my presentation is "Exercising the Coastal State Jurisdiction for the Repression of Piracy under UNCLOS, the Indian Perspective in the Light of the Inarica Case." The outline of my presentation, I'll introduce the introduction, the principle state jurisdiction which governs the exercise of jurisdiction in the ocean space, the universal jurisdiction for the piracy, the issues and the Inarica case incident which resulted in the arbitral award, the lesson learned. And in this light of this context of this arbitral award, India is drafting a maritime anti-piracy bill to fill up the gap in the national legislation as well as to comply with the obligation under the UNCLOS, and some concluding remarks. Okay, as we all know, piracy is a contemporary maritime challenge that we all face, especially the nation states in trying to address the violence, etc., in the maritime space. And the international law governing, particularly the UN Convention on the Law of the Sea, provide the international legal framework to combat piracy in high seas, including the universal jurisdiction. Since 2008, there was a surge in piracy in certain areas, certain geographical areas in the Gulf of Aden, in Africa, etc., which led to the multinational enforcement operations as well as the coordination mechanisms such as the contact group on piracy and this internationally recommended transit corridor. This picture shows the Indian Fusion Center, Indian Ocean Region annual report. This is a center operated by Indian Navy in New Delhi, which provides a situational awareness about the incidents on the sea. It is a coordination mechanism where we have the liaison officers from US, Australia, and the other naval officers, and they keep an eye on this. This report indicates that there is still high-risk region in subcontinent. Now, though this joint piracy operations in Gulf of Aden, etc., result in the steady decline in the piratical attack in recent time, however, the threat remains. And there are certain high-risk zones like the Gulf of Aden, Gulf of Guinea, the Indian subcontinent, the East Asia, and definitely the South China Sea. The IMB report indicates that there were 90 incidents of piracy and armed robbery from January to September 2022. And the Indian Infusion Center reports that the Indian subcontinent remains highly risky as far as the piracy is concerned. And recently, the UN Security Council also has adopted a resolution 2608, which urges the state to adopt national legislation to facilitate prosecution of pirates of the coast of Somalia. Now, coming to the UN UNCLOS, the UNCLOS provides the duty to cooperate, as we all know, under Article 100 of UNCLOS for repression of piracy on high sea. However, there are some issues in exercising of this coastal state jurisdiction for repression of piracy, because of the lack of rule of priority, as Dr. Judge Paik pointed out in the morning session. So that is the issue that I am going to touch upon. Coming to this principle of state jurisdiction, especially about the extraterritorial jurisdiction, we have these rules like territorial jurisdiction, nationality jurisdiction, passive personality, protective, and with respect to this piracy issue, we have the universal jurisdiction. The scope and the rationale of universal jurisdiction as for the with respect to piracy and other cases. Based on the nature of crime, irrespective of any connection, territorial or nationality, under the universal jurisdiction, states can exercise universal jurisdiction to try international criminals. And any court of any state can try perpetrator of serious crimes. The serious crimes presently includes piracy, is one of the oldest, the war crime, crime against humanity, genocide, torture, etc. The rationale being that bringing these perpetrators who are basically threat to the universal security and peace, they should be brought to justice and prevent the impunity, so that the state can exercise the universal jurisdiction. That is the rationale behind it. Okay. Under the UNCLOS, before coming to this UNCLOS provision, historically, pirates have been recognized as the hostis humanis generis, that is the enemy of mankind, which could be subject to prosecution and punishment wherever they are found. That historically, they have been treated like enemy of mankind. This has been incorporated in an UNCLOS provision, wherein Article 101 defines piracy as any illegal activity, act of violence, detention, or depredation on the high sea or in a place outside the jurisdiction of any state against another ship or against persons, property on board for private ends by the crew or the member of a private ship. Now, Article 100 provides the duty to cooperate, that all states, that is very important, that is all states shall cooperate on the fullest, to the fullest extent possible in the repression of piracy on high sea. This is the obligation under UNCLOS. However, there are issues that I mentioned, that this Article 105 provides the legal basis for exercising universal jurisdiction to seize the pirate ship, to arrest as well as prosecution of these by the national courts, to decide upon the penalties to be imposed and any other action to be taken. Now, there is an exception to the general principle that ship on the high, this is a general exception in the sense that the ship on the high sea are subject to the exclusive jurisdiction of the flag state. So this is a very important exception to the Article 92. This entails that both the coastal states as well as the flag states can exercise the concurrent jurisdiction in the this contiguous zone as well as the EEZ for repression of piracy. This is the very important issue, because in practice what happens, this situation may lead to conflicting claims or the pirated incidents by the flag state as well as the coastal states. For example, this Inirica case, which I am going to discuss in the next slide. The Inirica incident, as we all know, it happened on February 2012, where there was basically the two Indian fishermen were killed by Italian marine on board the Italian tanker Inirica Lexi in Indian continental contiguous zone at 20.5 nautical mile from the baseline, Indian baseline. And in that, subsequently, the two Marines were arrested and placed in judicial custody for prosecution for crime of murder before the Indian court in Kerala. Kerala is state in India. And the issue happened that Italy claimed the exclusive jurisdiction or the incident before the courts. However, the Indian Supreme Court, the highest court of the land in India, held that India is entitled to exercise sovereign powers up to 24 nautical mile. from the baseline and thus prosecute marine under the Indian Penal Code. That was that led to kind of a standoff for almost 8 years at the national level as well as the international. Finally, it went to Italy evoked the Article Annex 7 arbitration clause, arbitration under the unclosed provisions and dispute settlement procedures, and the matter went for the arbitration. In the arbitral proceedings, India claimed that Italy bears responsibility for acts of marines and killing fishermen, etc., and violation of certain provisions of UNCLOS. They relied on the principle of objective territoriality or passive personality. On the other hand, Italy claimed the exclusive jurisdiction of flag states on high sea under Article 92, etc., immunity of marine, because they contended that that is a part of their sovereign, they were performing the sovereign functions as a part of the naval detachment on the commercial ship, etc., and India has breached certain due regard obligation, etc. And they also challenged the Indian domestic law in this matter. As a result of this arbitral award, finally the arbitral tribunal gave the award in 21st May 2020. The important points which are important for us to ponder over, that it held that both India as well as Italy are entitled for concurrent jurisdiction. That is all right, but there are certain issues now that is for us to take it forward. India was asked to step aside the criminal jurisdiction in this matter, the national jurisdiction, and we have the Italian submission to investigate this incident. Italy had to pay certain compensation, but as far as this Article 100, the observation of this tribunal that is important for us is that it said that duty to cooperate under Article 100 and clause does not necessarily imply a duty to capture and prosecute pirates. It is a duty of continuing nature. It is not a one-point incident. It is a continuing nature, and this obligation could be implemented by including extradition and transfer of pirates and mutual assistance treaties that happens between the sovereign nations at the bilateral level, and conclusion of the bilateral as well as the multilateral agreements to facilitate such kind of cooperation at the international level. In view of this case, India is now considering making a national legislation to fill up its obligation on the UNCLOS as well. The salient feature, it is under consideration presently and is likely to be adopted this December at this session only. Now, the salient features of this bill to fulfill India's obligation to combat piracy. It is a national legislation to combat piracy in India's territorial sea, EEZ, and high sea. So just see how the nations are kind of adapting to their sovereign rights, exercising sovereign rights, because UNCLOS is only, the piracy is only in the high sea, not the territorial sea. All right. Now, the special provision for cooperation and repression of piracy in high sea and to provide for punishment of offense of piracy, to set up a designated court, national court at national level, with a jurisdiction to try this offense of piracy, and these offenses of piracy would be considered to be extraditable, subject to bilateral extradition treaty, as well as some sort of special procedure, operating procedure for the deportation and extradition of these pirates. Now, other important objective is to enhance India's maritime initiative to enhance maritime security of the Indian seas, trade routes, very important, sea lanes of communications. All right. Now, this importantly, this draft is also modeled on the IMO model law for national legislation for maritime criminal acts, as well as the legislation of Australia, drawn from Australia, UK, New Zealand, as well as Sri Lanka. Okay. Finally, to conclude my presentation, I would like to say that while the UNCLOS establishes universal jurisdiction of piracy, it does not specify priority. The rule of priority is not there governing the exercise of concurrent jurisdiction of the coastal state vis-a-vis the flag state. All right, especially in the contiguous zone and the EEZ. The scope and extent of coastal states' jurisdictional powers in the contiguous zone as well as EEZ continues to remain controversial or contentious. The Lexia Inerica case showed the exercise of enforcement jurisdiction by the coastal state in contiguous zone and EEZ has potential for conflict with the flag state's exclusive jurisdiction or the ship in the high sea area. All right. Now, in view of this, there is likely that a coastal state like India has taken now may take the legislative measures in exercise of the prescriptive jurisdiction, universal jurisdiction, part of universal jurisdiction to expand enforcement power. That is the creeping enforcement power now. That is the likelihood in absence of uncertainty. So in view of all this, I just want to point out that there's a need to initiate multilateral agreements to facilitate cooperation on piracy under Article 100 and clause, as observed by the tribunal, the arbitral tribunal in Inerica case. So with this, I conclude my presentation. Thank you very much for listening.
Thank you, Dr. Sonil, for your brief and concise presentation on the issue of how to repress piracy in the oceans. As you know, piracy is one of the most serious maritime crime, but still is occurring in the oceans around the world, and it threatens our maritime legal order, particularly shipping industry and shipping trade. But we are trying to overcome the piracy in the ocean, but we cannot yet. So just one thing, one problem is which country may have some jurisdiction in the contiguous zone or EEZ between the coastal state and the flag state. Still got a big conflict between two nations. Which one has priority of the jurisdiction on the piracy issues? Still, Dr. Sonil pointed out both the coastal state and the flag state may exercise enforcement jurisdiction based on universal jurisdiction in terms of UNCLOS and state practice. I do agree, I do accept his proposal. And also, I would like to suggest domestic laws and regulations will be a great role for the repression of piracy in terms of state practice and also national laws as well. Thank you again, and I want to move on to our panel speaker, Dr. Park Yong-gil. He is director of the Law of the Sea division of the KMI, and he will present a paper titled Marine Scientific Research in the Undelimited Maritime Areas, a quite hard and difficult topic. And so, Dr. Park, please, you have the floor.
Thank you, Chair. Good morning. My name is Yong-gil Park, working at Korea Maritime Institute. This morning, the title of my presentation is MSR in Undelimited Maritime Areas. Actually, I'm not in a position to answer this kind of very hot issue and unsettled issues. So, rather, I'll try to raise some question regarding the MSR in undelimited maritime areas. And also, part of my presentation overlapped with the previous the presentation of the previous speaker, Professor Nishimoto. So I'll try to skip some part of my presentation. Now I will start my presentation. First, about the MSR definition. There is no formal definition in UNCLOS, UN Convention on the Law of the Sea, but we may refer the CBD document adopted in 2003. In that document, described MSR as an activity that involves collection and analysis of information, data, or samples aimed at increasing mankind's knowledge of the environment and is not undertaken with the intent of economic gain. Is not undertaken with the intent of economic gain. So this implies that some activities relating to the oil and gas exploration are not will not be the marine scientific research activities. And relating to the MSR definition, we can raise some another questions. It is how to distinguish MSR from hydrographic survey, military survey, operational oceanographic, bioprospecting, and searching for archaeological or and historical objects on the water. So it is not, the answer is not clear now. Next, UN Convention on the Law of the Sea has the MSR part. It is the part 13. It's only for MSR. So in the coastal state has the right to regulate, authorize, and control marine scientific research in accordance with the relevant provision of this convention. And also, according to the Article 246, MSR shall be conducted with the consent of the coastal state. So the consent regime is very important concept in MSR regime. And let's look at some issue exercising jurisdiction in undelimited maritime area. When you say undelimited maritime area, it means areas that the coastal state claims jurisdiction over and has entitles on the area. And also, it means an area of overlapping claims by coastal states. So in this area, the coastal state may exercise its jurisdiction, its sovereign rights and jurisdiction unilaterally. So the unilaterally, this term means there is no need for consent from the other state. So Professor Nishimoto explained very well and comprehensively about the obligation of not to jeopardize or hamper the reaching of the final agreement based on Article 74.3, Paragraph 3, and 83, Paragraph 3 of the UNCLOS. So I will not closely look at the issue, but I think the criteria of jeopardizing or hampering the reaching of the final agreement is highly subjective concept, and there are many questions. And for example, who decides whether the activities constitute the criterion or not? It is largely depending on the position of the other or affected state, in that there will be no issue if the other state accommodate or acquiesce the activities and does not raise a question on the obligation. Let me just look at the separate opinion of Judge Jin-Hyun Baek. In the case of Ghana Cote d'Ivoire, he mentioned that answering a question of what actions would jeopardize or hamper the reaching of the final agreement, it depends much on the particular circumstance of each case. And he also mentioned a key criterion is whether the action in question would have the effect of endangering the process of reaching a final agreement or impeding the progress of the negotiation to that end. In other words, it is a result-oriented notion. So it is kind of a result-oriented approach. And he also provided some regarding some factors for assessing whether the conduct of a state would have the effect of jeopardizing or hampering the reaching of the final agreement. He suggests some factors like the type, nature, location, and the time of acts, as well as the manner of the activities. It is generally these factors can be regarded as a general objective factors. But my question is then, how about to add some subjective factors such as motives or purpose of the activities to assess whether some activities breaches the article of UNCLOS Article 74.3 or 83.3. The second question is related to MSR and relevant concepts such as hydrographic survey, military survey, bioprospecting, etc. The question is, what is implication if the activities of the other concepts do not require consent from a coastal state? In this case, in my opinion, the coastal state A cannot prohibit such activities of coastal state B in its claimed EEZ. In general circumstance, the activities will not cause the question of breaching Article 74, paragraph 3 of the UNCLOS. However, the question can be an issue of violation of the above article in special circumstance. Therefore, the reasoning suggested by Judge Jin-Hyun Baek is still effective in this case. Now, I'll move to the MSR and practice in Northeast Asia. As you know well, the East China Sea and the Yellow Sea in Northeast Asia, the distance is less than 400 nautical miles within the coastlines of Korea, Japan, and China. And also, there is no maritime boundary delimitation line between these states. But under the UNCLOS, each state has the rights to exercise jurisdiction in the area as its EEZ and the continental shelf up to 200 nautical miles. Under each domestic law, I mean the EEZ and Continental Shelf Act of each state, and concerning the scope of area for exercising jurisdiction in Korean law, according to the Korean EEZ and Continental Shelf Act, Korean government do not exercise its jurisdiction in the area beyond the provisional median line. So we can call it is a kind of self-restraint. And in Japanese EEZ and Continental Shelf Law Act, the maritime boundary will be the provisional median line. So according to Japanese law, the Japanese government cannot exercise its jurisdiction beyond the median line. But according to the Chinese law, there is no this kind of limitation. So the Chinese government, Chinese Coast Guard can exercise beyond in the area beyond the median line. So this is the main difference. And I think I can raise some question regarding the practice and the law of these three states. And the first question is the scope of undelimited maritime area is the same as the area overlapping claims between Korea, Japan, and China? In practice, the Korea and Japan do not exercise jurisdiction, including MSR, in the area beyond the provisional median line, and the Korea and Japan they protest about the activities of another coastal state when the latter state exercise its jurisdiction in the waters belong to their side from the median line. And then the question is how to evaluate some kind of low-level MSR activities of a coastal state A in the area very close to the territorial sea of a coastal state B. So those the standards introduced by Judge Peck works in this case. This is my question. And the second question is it is related to if the unilateral MSR activities are presumed not to reach the circumstance of the effect of endangering the process of reaching a final agreement or impeding the progress of negotiation to that end, is it legal and reasonable for the coastal state A protest the activities of the coastal state B? This is another question. And this is my this is the last slide of my presentation. The third question is about the different opinion about the scope of the undelimited or overlapping claims area due to the different views on the base points for the provisional median line. Korea and Japan has some disagreement for using some base points, some feature as a base points. So the provisional median line between Korea and Japan are different. So as a result, the overlapping area also different from Korea and Japan. So when a surveying ship of Japanese government conduct the survey in an area, Korea government requested stopping the survey and leave immediately, arguing that the area belonged to Korea's EEZ. And the last question is, what is the implication of a strong protest by a coastal state to the unilateral MSR activities of another coastal state between Korea, Japan, and China? Does the protest contribute to the circumstance of endangering the process of reaching a final agreement or impeding the progress of negotiation to that end? It may be some effect of accumulation. But as we noted, according to the UNCLOS and according to their domestic law, each state has the right to conduct MSR in the area, but the other state, when the state tried to conduct the MSR, the other state strongly protest against it and argue that it belongs to our EEZ, our content shelf, and the resisting state, so the resisting state violate UN Convention on the Law of the Sea. So, so my question is the implication of this kind of strong protest. So, this is my presentation. Thank you for your attention.
Thank you, Dr. Park's presentation regarding MSR in the undelimited maritime areas. You know, MSR is modern science research is to be recognized in terms of the UNCLOS and the EEZ, but still there are huge doubts on the definition of MSR. So I just suggest that it is possible to exercise MSR in overlapping claim area or undelimited area in terms of international rule of law. Still wondering. In particular, it is so sensitive because all the information from the name of MSR may be used for the military purposes. That's quite crucial one. So we need to define in details on the MSR because it might be another top issue and legal loophole as well. So Dr. Park suggests 4 questions. It will be quite difficult to be answered, but we'll try to take your answer. So thank you for all 3 presentations. Now I would like to have a time for discussion. We have designated discussant Professor Choi Ji-hyun from Jeju National University. Professor Choi, you have the floor, please.
Yeah. Thank you. Thank you for your kind introduction. And before starting my discussion, I want to extend my sincere gratitude to the Korea Maritime Institute and the Ministry of Oceans and Fisheries for giving me these wonderful chances having my discussion in front of these well-known scholars and experts, eminent experts. To make my discussion short, I will skip some part of my slide because those slides already explained well by our 3 presenters. The first slide explained about the legal rules, the only legal rules regulating overlapping maritime areas. That's the Article 74, Paragraph 3, and the Article 83, Paragraph 3. It only showed us some general obligation to make every effort to enter into provisional arrangements, not to jeopardize or hamper the reaching of final agreement. It is very important articles and general obligation, but it does not deliver us a specific criterion to how to judge the state permissible activities. So we need to focus on the other the case laws. First case law is the Guyana-Suriname case. It is already well explained by our presenters. That's the first case law, which provide us the clear understanding of Article 74, Paragraph 3 and 83, Paragraph 3 of UNCLOS. It delivers us some criterion as physical change. It gives many indication for the development of natural resources, for example, oil and gas, but it does not, unsatisfactorily, it does not give any implication for the exploration and exploitation of living resources or renewable energy facilities and marine scientific research and the new activities such as marine protected area or marine special planning or military exercise. With those considerations, that's the separate opinion Judge Park delivers us many delivers us good criterion. According to the separate opinion Judge Beck of this Ghana Cote d'Ivoire case, he showed us some criterion whether action in question would have the effect of endangering the process of reaching a final agreement or impeding the progress of negotiation to that end. It is a result-oriented notion. This key criterion depends much on the particular circumstances of each case. But it is not an answer to identify in general, in abstract, what are permissible activities in overlapping maritime area. So permanent physical change is not an absolute criterion to decide whether some activities in overlapping maritime areas are permissible or not. And also this separate opinion provides more flexible and encompassing criterion whether some activities are permissible or not in the overlapping maritime areas. If I add one more issues to these overlapping maritime areas, once a provisional arrangement covers joint development zone for natural resources, and if a provisional arrangement is terminated, especially by its termination clauses of the provisional arrangement, how Articles 74 paragraph 3 and 83 paragraph 3 would be applied. It would turn back into overlapping maritime areas, but the application of legal rules could be different from those of the free joint development agreement. If I take one more example to you, that's the Korea and Japan Joint Development Agreement, which has a 50-year duration with a 3-year prior notification terminated. So it entered into force in 1978, which means 2028, this Korea and Japan Joint Development Agreement could be terminated. What's the official position of Korea and Japan? The Korean position is that after designation of its concessionaire in 2008 and 2020, Korean government requested Japan to implement Japan's legal obligation, which means that Japan should designate its concessionaire in the joint development zone. But Japan's official position is a little different, not official position. Japan is assumed the legal position is a little bit different, and no concessionaire was designated by Japan because there is scanty possibility of commercial development in this joint development zone area. After 2028, Korea-Japan Joint Development Agreement could be terminated by perhaps Japan's prior notification in 2025. If then, what is the legal status of Korea and Japan Joint Development Zone? I don't know what would be the fate of this joint development agreement between Korea and Japan after 2028. It could continue even after 2028, or it could be terminated in or after 2028. If it is terminated, what kind of legal rules would be applied, and what is the legal shape of application of those rules, especially Article 74, Paragraph 3, and Article 83, Paragraph 3. Those articles are legal rules that would and should be applied even after the termination of Korea and Japan Joint Development Agreement. But the result of this application or shape or mode of application would be different. If we take the separate opinion of Judge Beck in the Ghana Cote d'Ivoire case seriously, particular circumstances should be considered seriously, especially after its termination, joint development zone agreement between Korea and Japan. Both states' different legal position at the time of its implementation could have legal effect on both states' permissible activities from the time of its termination. Permissible activities for Korea, which insist continuous implementation of joint development agreement, could be different from Japan, which insists no possibility of commercial oil and gas development in this region. So, at least for Korea, some unilateral activities, for example, unilateral seismic survey or even exploration drilling, could be permissible activities after termination of Korea and Japan joint development agreement. That's the result of my discussion with a very neutral perspective as a legal expert, but slightly mixed with Korean perspective. Thank you for your concentration for my discussion. Thank you.
Okay, thank you, Professor Chair, for your discussion on the issue of the how to exercise some activities in the particularly undelimited area in terms of the Japan-Korea joint development zone area in the southern part of the Korea, I mean, is China Sea. So we had the chance to take some 3 presentations and also 1 discussion. Now we have just 10 minutes now, so I would like to open the floor to take some questions or answers. Yeah, please, Kono, yes, please.
Thank you, moderator, and congratulations to panelists. It was very insightful and interesting to listen to your presentations. I'd like to ask a question to Dr. Park. In respect to your question too, it would be interesting to hear your views as to how you understand who has the title to give the consent for MSR in disputed areas. If we look at Article 246, paragraph 2, it is interesting in my view to note that the provision question uses the expression "the coastal state" as the determiner. I would think you could argue that it's a qualifier that the state must have entitlement into the area in question. And although I recognize that, as you rightly pointed out, that it may be difficult to determine the extent of entitlement, given that relevant base points may be difficult to identify for any party. But I would think that'd be an interesting element to explore further. With the acceptance of the moderator, I'll also ask, make a comment, ask a question to Professor Nishimoto. When I read initially the judgment of the Special Chamber in Ghana, Cote d'Ivoire, what struck me as really interesting was the fact that its deliberations on whether or not the delimitation operation is constitutive or declaratory. And in that regard, it made a very interesting obiter dictum to the extent that allowing exploitation, and even if State A had exploited hydrocarbons on the other side of the maritime boundary, that is on the continental shelf of State B, it would, notwithstanding, be contrary to its obligations to the extent that it was exercised on the basis of good faith. Now, if we look at the origins for the inherency doctrine, namely to avoid that states would unilaterally issue licenses and explore in vast areas of continental shelf, I would think it difficult to reconcile that approach in respect to the inherency doctrine and also to paragraph 2 of Article 77, providing explicitly that no other state may entertain any activities in the continental shelf of a state. So therefore, I would think it would raise many questions, and I would be interested to hear your views on that. Thank you very much.
Thank you, Professor Konoi, and you have you suggest 2 questions. The first one will be Dr. Park, and the second one will be is Kentaro. And Dr. Park, can you answer the question, please? Yes.
Okay, thank you for your very difficult question. I'm not sure, but if I'm wrong, please tell me. In my understanding, under MSR regime, in the EEZ and the continental shelf, especially relating to Article 246 of UNCLOS, my understanding is that all coastal state has entitlement for the MSR in the area up to 200 nautical miles until the coastal state enjoy the right until the maritime delimitation is confirmed. So pending the delimitation agreement, so each coastal state has the right to exercise in the area unilaterally without the consent of the other the claimed state. This is my understanding. So because of this kind of the overlapping claims are produced, so I think the third UN conference made the Article 74.3 and 83.3 paragraph 3. So this is my understanding. I'm sorry that it is not enough answer to your question.
Yeah, thank you, Dr. Park, for your brief answer to the question. And Professor Kantor, you have the floor, please. Just.
Yes, so thank you for the very difficult question also addressed to me. I think the idea that maritime boundary limitations are constitutive rather than declaratory can be reconciled with the understanding that coastal states do have inherent rights over their continental shelves due to the reason of that area being natural prolongation. I think it's simply that there is some unclarity as to the extent extent of the right when there are overlapping entitlements. So I think the two issues can be distinguished to that extent, although I do appreciate your point on that. And also in that relation, perhaps in relation to the topic discussed today, if I remember correctly, I think the discussion regarding the nature of maritime boundary delimitation was in relation to the issue of responsibility. So I think the question there was whether a state could be held responsible for a violation of a sovereign right because it was found to be acting on the other side of the delimitation line. And the point made there was that if a party had conducted in good faith, then it would not bear responsibility for a violation of sovereign rights. I think that is different from the question of whether a state had violated the obligation and not to jeopardize or hamper the reaching of the final agreement. I think the tribunal dealt with those issues as separate issues, and I think a distinction perhaps can also be made in that regard. So I think that would be at least my partial answer to your question. Thank you very much.
Okay, Professor Kantaro, for your answer. And then there's another. You. Some young gentlemen, you raise your hands. Yes, please.
Sorry, I'll be very brief. Thank you for the wonderful presentations. Question for Professor Nishimoto. To what extent do you think that the criterion of permanent physical change relates to environmental degradation in a disputed maritime area? And the second question is, do you think that activities involving the threat or use of force in a disputed maritime area would always be in breach of Article 74, Paragraph 3 and 83, Paragraph 3? Thank you very much.
Okay, who will answer the question raised by the young scholar? Kentaro? Yes, please.
Yes, thank you for the question. I think the first one is rather difficult, but I think the point or the rationale behind the understanding that permanent physical change would be one criteria is that it is irreparable. So based on that, if you have a very serious situation where you have a degradation of the marine environment, I think you can take that in favor of the understanding that any acts causing irreparable, for example, degradation of the marine environment would violate the obligation not to jeopardize or hamper the reaching of the final agreement. I think that could be perhaps be sort of deduced from the rationale given in the Guyana-Suriname case. On the other hand, I'm not sure, but I think the answer would be yes. And I'm not sure even if there is a sort of an additional value to discussing whether that is a violation of the obligation not to jeopardize or hamper, because it would be a clear violation of another rule of international law anyway. I think that would be the answer to your question. Thank you very much.
Okay, thank you. Yeah, Dr. Yaras, please. Yes, you.
Thank you, and I would also like to thank for very engaging, very interesting presentations and comments. Many thanks. And my question goes to the Director Park. I was, well, let me start with the fact that the United Nations, especially our division, which is Secretariat of UNCLOS, is always promoting cooperation among states, among all stakeholders. This is part of our mandate. So in fact, cooperation also, especially as it concerns marine scientific research, is very important. The whole spirit of UNCLOS is to facilitate, to promote marine scientific research. And I would also put into the package the fact that the convention needs to be read as a whole, and there is a special obligation of cooperation among states in semi-enclosed and enclosed seas. So from that perspective, and the perspective that even if a state, for instance, these states do not have diplomatic relations, it still is under normal circumstances considered that the consent for marine scientific research should be given. I would like you to comment, why would be perceiving activities in regard to MSR as a competitive field, which somehow leads to the even hampering of reaching agreement, rather than approaching it from the spirit of cooperation and facilitated the utmost on part of those coastal states which have overlapping claims to cooperate, especially because they have an obligation to share the results. So in fact, both tend to benefit from that activity. Well, that's if you could comment on that aspect. Thank you.
Okay, thank you for your comment. And David Ong, Professor, please you.
Thank you very much, Mr. Chair, for giving me the opportunity. I'd like to direct my question actually at Dr. Agarwal's presentation, and I'm afraid that it is a difficult one. Can I just ask that in light of the new Indian legislation, possibly proposed new Indian legislation, if the situation in relation to Erika Lexi occurred again, so if it repeated itself, would India now be confident that it would be able to assert jurisdiction over the Marines in order to retain prosecution rights or prosecution jurisdiction? Thank you.
Okay, Sonil, you may answer that question, please.
Thank you, Dr. Ong, for the question. Very difficult one because no country is going to concede enforcement jurisdiction to the other state. There is it happens again. Look, there are two parts to it. One is the international obligation that we all have, and another is the domestic kind of legal authority that the sovereign state enjoy. So the decision making takes place at the highest level when it comes to take up the matter at the international level. And I am doubtful whether the government of India is going to concede to give up the enforcement jurisdiction. That is why, if you see this present bill, it actually is basically creeping of jurisdiction. Because prior to this Lex Erika, there was no legislation, and they tried to impose bringing some old legislation like the Indian Penal Code, etc., and then the procedural matter, the Criminal Procedure Code, etc., to somehow justify their action. In fact, at that time, I remember I was because I was part of the government only. So immediately somebody called me, a top naval officer, basically to take my view. I just asked one question to him: what is the location? He said it is beyond territorial sea. I said then you don't have any jurisdiction. That was my simple. But subsequently I found, because I am privy to all this deliberation, etc. Because government deliberation takes place in different, zone. No, that is a point that I am trying to say. The sovereign nations are very difficult to, to deal with their behavior. You never know, because the national security requirements, the national other issues, they prevail over the legal arguments, And in our system, at least in our structural system, the governance is not by the legal experts. It is dominated by the political class. And I don't think that, again, I think it will happen. So that is why the clarity is required. There must be some sort of multilateral negotiations, that is required to have some sort of clarity or the rule of priority, as pointed out by Judge Paik. That is what is required. I think.
Okay, thank you, Sunil. And time is running out, so I'll test one more. One, two, three, two. Yes, please just concisely ask a question, please. Ladies on the back side. Yes.
Thank you very much. My question goes again to Dr. Agrawal's presentation. First, I have two questions. First question is, can IUU fishing be considered as piracy? And the second question is, if so, you mentioned about the Anti-Maritime Piracy Bill of India, and you mentioned about the cooperation between countries for anti-piracy activities in the high seas. If so, and we have, I'm from Sri Lanka, and Sri Lanka and India has IUU issue for a long time, and in that case, if countries have that kind of disputes, how come they can cooperate to overcome piracy?
Okay, sorry, you may also have.
Thank you for the question. In fact, India and Sri Lanka have a long battle over Ketchavu Island, as far as I remember. Because if you see the geographical location, they're very close, and there is a lot of fishermen which pass over, because the fishermen are not supposed to know the boundaries, and there's no boundary, as we all know, in the ocean region area. So this happens. Extending this IUU fishing to piracy, in fact, if you see, the piracy has been defined by the UNCLOS 101. Still, the countries, in order to extend their jurisdictional, that is the thing, prescriptive jurisdiction as well as enforcement, because there are three kind of jurisdiction that we have: prescriptive, then we have the enforcement, then we have the adjudicated jurisdictions. All right. So enforcement issue is most contentious, not the other one. You may have prescriptive national legislation, etc., but enforcing that is important. And if you see this piracy bill that we have, it broadens, piracy activity includes all sort of activities, illegal activities, they say, criminal activities. So more than this piracy, certain criminal activities will also be covered under this piracy bill, just to give a broader ambit to the enforcement authority, that is the coastal, we have the Coast Guards and the Navy. So I think it is not a settled issue, and most likely it could happen unless there is a kind of a political solution. All right, so that is the only way forward, because legal issues are also linked with the political kind of a scenario. Thank you.
Okay, thank you, Sunil. And Mr. Kim, do you want to ask a question, please? Yes, just.
Thank you. Let me express my appreciation to speakers, particularly to Professor Nishimoto for his excellent presentation. I have a comment, another question on his presentation. In my view, the obligation of self-restraint may be understood to be to a certain extent, the other expression of the obligation not to aggravate or extend the dispute although the former scope may seem to be broader than that of the latter. The obligation not to aggravate or extend the dispute is usually addressed in the provisional measures orders issued by the international courts and the tribunals. This obligation was first raised in the case legal status of the southeastern territory of Greenland in the early 1930s before the Permanent Court of International Justice. Statutorily, the obligation not to aggravate or extend the dispute is based on the rules of the ICJ. It appeared first in the rules adopted in 1936, which reads, the court may indicate the interim measures of protection other than those proposed in the request. This provision has been maintained in the subsequent rules of the ICJ and also incorporated with some changes in the rules of the International Tribunal for the Law of the Sea. I think that jurisprudence concerning the obligation not to aggravate or extend the dispute appears to be consistent and well settled. The obligation of self-restraint seems to be an important element in the maritime delimitation dispute, and I understand that this point was underlined by Judge Beck in his separate opinion in the Ghana Cote d'Ivoire case. Personally, I strongly hope states having pending delimitation issues, including those in the Northeast Asia, should be more sensitive and cautious in the obligation of self-restraint, which may be critical in not jeopardizing or hampering the reaching of the final delimitation agreement. Thank you. Thank you very much.
Okay, thank you for your kind comments. And there's no more questions. So thank you all. And as a moderator, I want to thank you to all presenters and also discussants as well. And as you know, there are so many maritime boundary disputes, such as legal uncertainty, political will, dispute sovereignty, access to maritime resources, fishing security, geological, geomorphological factors, trade issues. So many issues are to be involved in the maritime disputes. That's why it is quite difficult to solve the maritime disputes. But we need to solve the problems because it may cause so many legal disputes, conflict issues among the concerned countries. And the 427 potential maritime boundary disputes, it's just 168 cases were settled, were agreed. Still, we have 60% of maritime disputes are pending. So serious problem in our oceans. So, of course, we may agree, we may negotiate, we may submit to the court, but it will take time. Maybe who has the legal responsibility for that? Is individual countries or judges? Of course, maybe judges may have the authority to decide the cases. So through this session, we may recognize, we may accept so many current legal issues, particularly in the undelimited areas, so-called overlapping claim areas. Still, we have to overcome, we have to solve, we have to find out some solutions through the international rule of law, safe practice, and also national legislations. So in this session, we could have quite productive consequences from the three presentations. So as a moderator, I would like to end this session officially. Thank you for your cooperation. Thank you.
Thank you. I'd like to thank all the speakers and discussants and audiences for your contributions. The afternoon session will begin at 1:30, 1:30. Now we are going to break for lunch. Today's lunch is served as a buffet. Food is preparing in the hallway. You can have lunch where you are sitting or standing. Use the standing table outside. Thank you very much.
끝났네. 그게 세션. 그러니까 그래서 딱만 끝난 거지. 그러니까 그래서 아주 잘 지켰어요.
I did not notice you when I saw your picture, but yeah. But when I hear your voices,
Very beautiful presentation.
아직 5분 남았는데 올라오시라 할게요.
올라와 계셔야 되고.
네.
예, 그 어나운스를 뭐 조금 늦게 2, 3분 전에 하셔도 되는 거예요. 올라오네. 프로페서 라롱.
I did. I did. Wonderful things. I wasn't always sure if it was a Korean.
You are familiar with the Korean food?
Not so much. Although even in Montreal, there's some sweet Korean restaurants, but I don't know if they're but this is a big thing from all over the world.
Yes,
I don't know
yes.
if, I'm sure it's not like this, but it's not like this. So when I see it, so in Montreal like weather,
Yes, but you have much more snow in
and the
Montreal.
big storm coming on Friday, 30 centimeters.
30.
Oh yeah, yeah. And I left my 18-year-old daughter with the half the shovel. She was like, me? I said, yes.
Well, I lived twice in New York. That's fine. I was in Canada.
But so here in Montreal, this is
That's enough.
this is just a
Very
decorate.
cold. Very cold. But that's enough.
Thank you very much for moderating our questions. Yeah, thank you. Thank you.
Good afternoon, ladies and gentlemen. We are going to get started session 2 now. All speakers and discussants, please take your seat on the stage. 저 밖에 계신 이 참석자분들 안으로 안내 부탁드립니다. Now we start the session 2, which will be discussing about the military activities in the EEZ. Moderator of this session is Dr. Park Hee-kwon, Distinguished Professor of Hanguk University of Foreign Studies. Now I will turn the session over to him.
Thanks. Good afternoon, everyone. I think I'll start. First of all, I wish to thank the organizers of the conference for inviting me to this conference and allowing me to moderate this session. Before I introduce the panel, I will provide some context for this session. As we are well aware, the theme we'll be talking about in this session is military activities in the EEZ. This subject of military activities in the EEZ was a very controversial one at the third UN Conference on the Law of the Sea As a practitioner of the law of the sea, I myself participated in the third UN conference, and we diplomats tried to balance the rights and interests of coastal states with those of maritime powers. But we have failed to do so. So differing viewpoints exist in state practice. The basic problem is that it is still not clear from the convention whether military activities in the EEZ are included in the freedoms of navigation and overflight and other internationally lawful uses of the sea available under the Articles 58 and 87 of the Convention. Therefore, some coastal states maintain that other states cannot carry out military activities in or over their EEZs without their consent, and have sought to apply restrictions on the freedoms of navigation and overflight. How to balance the legitimate interest and rights of coastal states with the overall interest of the international community will be a major concern in the years to come. With that, let me briefly go over the ground rules for this session. We have 3 speakers and discussant. 3 speakers will each speak for 15 to 20 minutes. After that, Professor Kim will discuss 10 minutes. That will be enough? And thereafter, we'll get into a question and answer period. With that, let me introduce speakers. Today, we have 3 distinguished speakers and 1 outstanding discussant. Professor Byeorun Kunoy, Professor Dustin Wang, Professor Susan Lalonde, and Professor Kim Hyun-jung. How about a round of applause for the speakers who have traveled from afar to be here? Thanks. Let me briefly introduce each speaker. Dr. Kunoy, Byeorun Kunoy, is Professor of International Law at the University of Faroe Islands. During his tenure as legal advisor at the Department of Foreign Affairs of the Faroe Islands, he has acted as agent and counsel in Annex 7 arbitral tribunal proceedings and chaired WTO DSU proceedings. He has also chaired at the CLCS, Interstate Maritime Delimitation Negotiations, and others. Dr. Wang is a professor of political science at the National Taiwan Normal University. He obtained his PhD in international law from University of Bristol, UK. He actively participates in maritime activities concerning the law of the sea. Professor Wang is a member of numerous academic associations, including the Chinese Society of International Law. He contributes his research works in various academic journals, such as Ocean Development and International Law and Pacific Review. Next, Susan Lalonde is a professor of public international law and the law of the sea at the University of Montreal. She got a PhD in public international law from the University of Cambridge. Her research and publications focus on the determination of boundaries on land and at sea, with particular emphasis on the Arctic. She was a member of the ILA Commission that reported on baselines under the law of the sea and the co-editor of Ocean Development and International Law. Professor Lalonde is a member of the Canadian Arctic Security Working Group. Dr. Kim Hyun-jung is professor at Yonsei University. Her main research fields are law of the sea, international institutions, and interrelations between international law and politics. Now, with that as a short introduction, let's listen to the presentations to be made by speakers. Now, it is with great pleasure that I welcome Professor Kunoy as our first speaker.
I think it works now. Very good. First of all, thank you for the very kind introduction to the moderator. And I would also like to extend my gratitude to the organizers of this excellent conference to allow me to give this presentation today. It's a great honor and I feel privileged being here. The topic that was given to me is to present the military activities exception, the exception within Article 298, paragraph B, subparagraph 1 of UNCLOS. This notion is has been relatively untouched. It is only in 2015 that an arbitral tribunal is in position to interpret, share its understanding of how this notion is to be understood. Since then, there have been 4 decisions of tribunals and courts, which I think fair to say have elaborated considerably as to how we should understand this particular notion. Now, those of you familiar with Part 15 would know that under Section 2 there is a compulsory dispute settlement mechanism, but under Section 3 states have the possibility to make some general exceptions to the compulsory dispute settlement mechanism in Section 2. And one of these exceptions relates to disputes concerning military activities, including military activities by government vessels and aircraft engaged in non-commercial service, and disputes concerning law enforcement activities in regard to the exercise of sovereign rights of jurisdiction excluded from the jurisdiction of a court or tribunal under Article 297, paragraphs 2 and 3. I shall say that it is now established that it does not matter what the nature of the vessel is, be it naval or civil, it may fall within that exception notwithstanding. It's important to have in mind that where states do not make use of this optional exception, courts and tribunals under Section 2 would have compulsory jurisdiction to settle such disputes. I believe that there are approximately 27 or 28 states parties that have made use of the military activities exception. Military activities, what does this entail? I think this would be a concept which one can say deserves the precision of being made of courts and tribunals. As such, it is difficult to list its composite elements. But the argument has been raised in academia that given the nature of these disputes, there should be an interpretation of Article 298(1)b in deference to the sovereignty of states, the so-called canon of treaty interpretation called in dubio mitius, but which I believe fair to say has been disregarded, rejected by the relevant courts and tribunals in these particular decisions. I'm referring particularly to a paper published by Stefan Thalmann
advocating that principle. So the interpretation of Article 298(1)(b) is conducted according to the general rule of interpretation, notwithstanding its sensitive nature. The first court and tribunal seized with a dispute relating to military activities is the South China Sea arbitration. It is generally, I believe, fair to say, considered as establishing a low threshold for constituting dispute concerning military activities. According to the arbitral tribunal, the mere involvement of the military forces may, in certain circumstances, be sufficient to falling within the optional exception in question. In this regard, it's worthy to pay attention to the standoff of the Second Thomas Shoal, which Chinese government vessels sought to prevent the resupply and rotation of Philippine troops, conducting the arbitral tribunal to hold the view that this represents a quintessentially military situation involving the military forces of one side and a combination of military and paramilitary forces on the other, arrayed in opposition to one another. So this has been classified as a quintessentially military situation, notwithstanding the core of the disputes of the parties in question. And as we shall see, other tribunals have decided differently, I believe, fair to say. I've classified the second category as a middle-level threshold. You will note that in Section 2 and Section 3, there are provisions making use of the formula arising out of, arising from, which arguably has a broader application than the preposition concerning. And in the Coastal States Rights case, which I believe fair to say establish a middle level of threshold falling within the optional exception, this difference was highlighted. I believe it was Article 298(c), which refers to arising out of rather than concerning. According to the arbitral tribunal, the preposition concerning circumscribes the military activities exception by limiting it to those disputes whose subject matter is military activities. Now, circumscribe means to limit something, according to the Cambridge Dictionary. And the use of the term concerning circumscribes the military activities exception by limiting it to those disputes whose subject matter is military activities. Accordingly, it's quintessential to determine what is the subject matter of a dispute, rather than looking at whether or not military force is being used, I believe fair to say. Further, in the Coastal State Rights case, the arbitral tribunal held that the alleged force appears to have been directed towards maintaining civilian activities, such as the exploitation of hydrocarbon and fisheries. In the arbitral tribunal's view, a mere causal or historical link between certain alleged military activities and the activities in dispute cannot be sufficient to bar an arbitral tribunal's jurisdiction under Article 298(1)(b). I believe this to be descriptive rather than constitutive. It does not necessarily mean it has to be a causal or a historical link, but it may be. Now, it is beyond doubt that the arbitral tribunal in the Coastal States Rights case, and we also see this in the provisional order of ITLAS in the detention of 3 naval vessels, that much importance is being put to the preposition concerning. Again, I'm reiterating my statement earlier, or the statement of the tribunal. Compared to such other terms, which are open to a more expansive interpretation, the term concerning circumscribes the military activities exception to those disputes whose subject matter is military activities. Whereas one may have sympathy with this finding of the arbitral tribunal, there are precedents in other cases which come to the complete contrary conclusion. Now, in the fisheries jurisdiction case in dispute between Canada and Spain, the ICJ held that the words of the reservation exclude not only disputes whose immediate subject matter is the measures in question and their enforcement, but also those concerning such. That is to say, those disputes which, in the absence of such measures, would not have come into being. And we see also this in the ruling of of Itlas in the Louisa case that the use of the term concerning in the declaration indicates that the declaration does not extend only to articles which expressly contain the word arrest or detention, but to any provision of the convention having a bearing on the arrest or detention of vessels. So we have here different case law attributing different meanings to how to understand concerning. And one could argue that this is worrisome. But fair enough, it should be mentioned that in fisheries jurisdiction case and also in MV Louisa, what was at stake were unilateral acts. It is established, well, in international case law, that unilateral acts need not necessarily follow the general rule of interpretation in Article 31 of the Vienna Convention Law Treaties. It follows from the conclusions of the ICJ in the fisheries jurisdiction case and also reiterated in Louisa that special attention is given to the intention of the party in question. Then the question arises, well, to the extent that a state party's UNCLOS makes use of the optional exception 2981B, is this not also a unilateral act? The argument could be made. But the difference being that in this particular case, the flexibility to derive from the particular wording in 298 is circumscribed. But in any event, I think that these are interesting developments that should be given further consideration and also make question of whether or not, to what extent in the affirmative, attention should be given to the preposition concerning in Article 2981B. Maybe rather than looking at concerning, it may be useful to follow the practice, the mere practice of courts and tribunals to determine what is the real object of a dispute, rather than emphasizing on what, in the affirmative, which attention should be given to the preposition concerning, given these circumstances. And as a matter of fact, it appears that going forward, the Arbor Tribunal in the Coastal State Rights case and also ITLAS looks in depth onto what is the object of the dispute in order to determine whether or not it falls within Article 2981B. Now, in our Libertat, ITLAS held that a warship is an expression of the sovereignty of the state whose flag it flies. One could be tempted to argue that, given this statement, to the extent that a naval vessel shoots targeted shots against another naval vessel, it would be difficult not to see this as a dispute concerning military activities. I'm not saying I'm making the argument, but the argument could be made. As a matter of fact, in the detention of 3 naval vessels, as some of you would know, the Russian vessels in question, they shot targeted shots at the relevant Ukrainian naval vessels, inflicting damage, material damage on the vessels, and also injuring the personnel on the vessels. One could be tempted to make use of the approach of the Arbor Tribunal in the South China Sea arbitration, referring to what is a quintessentially military activity. Yet, according to ITLAS, what is of relevance, of importance, is to determine the underlying dispute. And according to the ITLAS, the underlying dispute leading to the arrest concerned the passage of the Ukrainian naval vessels through the Kerch Strait. This was this dispute relating to Article 7, to the interpretation application of UNCLOS. It continues, at the core of the dispute was the parties' differing interpretation of the regime of passage through the Kerch Strait. In the view of the tribunal, such a dispute is not military in nature, notwithstanding that targeted shots had been inflicted upon the Ukrainian naval vessels by Russian naval vessels. Now, going back to the order on provisional measures of ITLAS, it held further that whether the arrest and detention took place in the context of a military operation or a law enforcement operation is of importance. Operation, where does this come from? Article 2981 does not rely on the approach operation, it refers to activities. An operation, according to the Cambridge Dictionary, is the fact of operating, whereas activity is a situation in which a lot of things are happening. One's inclined to believe that a military operation has the object, a particular object, a purpose, whereas a military activity could perhaps be more randomsome. According to Itlas, in its view, considering the above sequence of events, what occurred appears to be the use of force in the context of a law enforcement operation rather than a military operation. So these are interesting developments by Itlas. Now this finding of Itlas, as you saw, has been classified by myself as a high threshold. It's difficult, it may be difficult to reach, to fall within the exception following the standard in question, but the exercise of jurisdiction of Itlas in that particular case was exercised under Article 290, paragraph 5 of UNCLOS, that is, awaiting the constitution of Arbiter Tribunal pursuant to Annex 7. And more recently, the Arbiter Tribunal rendered its award and preliminary objections, and it does not accept the rigid either-or proposition espoused by Ukraine. Now, in the order and provisional measures, it was held that either it is a military operation or it is a law enforcement operation. In the absence of being a military operation, it cannot be a military activity. It remains to be seen whether Ukraine relied on this distinction on the basis of a military operation or military activities, but it would follow from the context of the subsequent paragraphs of this excerpt from the award of the Arbiter Tribunal that it sees this as the either approach which was embraced by Itlas in the order and provisional measures was pursuant to operations, whereas the Arbiter Tribunal looks at this as activities. Further, I believe fair to say that the Arbiter Tribunal in question revisits the finding of, to some extent, the finding of Itlas in the order and provisional measures, and also departs to some extent to the Russia that underlies the decision on the preliminary objection in the arbitral, in the dispute on the coastal states' rights case. So the Arbiter Tribunal develops that there were three sequences. First, there was a lengthy period of standoff between the two states, with the vessels of one surrounded by the vessels of the other. In the view of the tribunal, this confrontation between the vessels of the two states involved military activities within the meaning of Article 2981B. The previous decisions have all emphasized, notwithstanding the difference that could be attached to concerning or by contrast to other provisions, but what is at stake is not military activities, but rather disputes concerning military activities, which appears to be omitted or disregarded by the Arbiter Tribunal in question. But in any event, this part of the confrontation is beyond the jurisdiction of the Arbiter Tribunal according to its operative paragraphs, whereas the Itlas concluded that the entire operation was not a military operation and therefore not a military activity within the meaning of Article 2981B. Secondly, the Arbiter Tribunal concludes that the period from when the Ukrainian vessels began to leave the anchorage area and were ordered to stop and continues until the vessels were boarded and the crew arrested is the second period, but it refers to the merits to decide on whether or not this falls within the exception. Whereas thirdly, the continued detention of the vessels and their crews and the prosecution of the Ukrainian servicemen are law enforcement activities. But it is interesting to note that in the order and provisional measures of Itlas in this same dispute, it held that the third segment, as listed by the Arbiter Tribunal, was just supported the conclusions it had done in respect to the entire sequence of events that preceded that particular stage, that it was not constitutive of not being a dispute concerning military activities, but rather just confirms what it had held with regard to the previous incidents, which related to a dispute, the core of which is free passage of Kerch Strait, according to Itlas. So we see some interesting developments, I believe fair to say. Remains to be seen how this will develop in the future. From this, I shall conclude, make some concluding remarks very rapidly. So as I mentioned, there is this jurisprudence, one can say these different approaches have crystallized since 2015. We can see that there are different approaches, which is not unusual given the particular system, the genome of how Section 2, Part 15 operates. There are different courts and different tribunals and different people on the bench in these particular forums. So it may inevitably be difficult having a uniform approach to such sensitive questions. But I would think that to what extent one may attach importance to the proposition concerning may be something that should be given further consideration going forward, given the differences that have been given to this particular notion in other cases. And finally, I look forward to seeing the award on merits in the detention of 3 vessels, but also most certainly the award on the merits in the Coast State Rights case, which is presided by Judge Pike here present here today. One final note in this regard also I'd like to add is that I would think it's no coincidence that the approaches which are apparent in Coastal States Rights and also in the provisional order on the detention of the 3 naval vessels is more or less similar. I would think fair to say that it is noteworthy that 4 of the members of the Arbor Tribunal, which rendered this award in 2020 in the Coastal States Rights case in the preliminary objection stage, were judges and ITLAS at that period of time. Whereas if we look at the members of the Arbor Tribunal in the detention of 3 vessels, none of the arbitrators are members of ITLAS. I think this is illustrative of the challenges that underlie the operation of Section 2. And with this, I'll thank you very much for your attention.
I thank Professor Kunoy for his thoughtful and thought-provoking presentation. He analyzed the meaning and scope of military activities exception under Part 15 of the Convention. I think he rightly concludes that still we have not found any strong case law supporting the particular construction of Article 2981B. Now I turn to Professor Wang for his remarks.
Thank you, moderator, Professor Park, as well as all the distinguished guests, ladies and gentlemen. First of all, I would like to express my gratitude to the organizers, Ministry of Oceans and Fisheries, as well as the Korean Maritime Institute, especially Dr. Park Yong-kil for including me in this important meeting. When I say this is important, not only because this year marks the adoption of the 40th anniversary of the UNCLOS, but also for other, we all know that there are a lot of conferences talking about the 40th anniversary of the UNCLOS. However, most of them, they are talking about the achievement of the UNCLOS. And this conference, we are going to talk about some of the unsettled issues. So I would like to say that this is a really important conference for us, just because we have to review those issues, and also we can find out some certain disputes on the different interpretation on certain articles of the UNCLOS, so that we could move on to a more settled world. So my issue talking about is about the military activities in the EEZ and the freedom of navigation. So I am going to talk about some of the issues happened in the East Asia. First of all, I would like to mention we have quite a difficulty on defining the term military activities. Basically, military activities in the EEZ is a contentious issue of the international law of the sea. And also, for the past 40 years, we never can settle this definition. Military activities covers quite a wide range of activities, for example, like naval operations, from freedom of navigation and the right of intercenter passage through the warship transit to exercise or to operate involving ships, submarines, and aircraft, which even may include the use of live fire. So another issues talking about this, that will be what about the scientific research by military based ship? I think we could find out the, some of the cases happened for the past. And actually, we can find out some of the scholars, they get together and to make a guideline for navigation and overflight in the exclusive economic zone in 2005. According to that guidelines, military activities has been understood as meaning the operations of military vessels, aircraft and devices, including intelligence gathering, exercises, trials, training, and weapons practices. However, this is only the academic point of view. It is really difficult to find out the real practices from the different states. So probably just like Judge Peck clearly mentioned this morning in his keynote speech, that the nature of the EEZ is a kind of a sui generis nature, which would generate various questions on the rights could be exercised between territorial sea and the high seas. Nonetheless, this might be the center of the conflict. Actually, we can find out one of the incidents happened in 2009. That is the United States, it's a scientific research vessel from the Defense Department, impeccable incident. That incident between the United States and China, we can say that is a notable case. What even more serious and noteworthy is that if such kind of conflicts could not be properly managed, the crisis may be escalated and also would be damage the security of the region, even worldwide. So this page, I would like to show that actually the UNCLOS provides coastal states with authority over certain foreign military activities. And actually, ships in innocent passage in the territorial sea may not engage in certain military activities, including threat of use of force and use of weapons, intelligence gathering, acts of propaganda, launching and landing of aircraft and other military devices, which is about the right of innocent passage. But it is within the territorial sea. So how about the rights that the foreign ships, also the foreign, the foreign warships that could exercise, and the same restriction applied in archipelagic waters, submarines, and other underwater vehicles engaged in innocent passage in foreign territorial sea, and archipelagic waters must navigate on the surface and show their flag. So this is also about the issues of the right of innocent passage in the territorial sea. Ships engaged in transit passage or archipelagic sea lanes passage may not conduct survey activities and may not threaten or use of force. But the problem is we cannot find out the similar restrictions in the UNCLOS about the Part 5, and therefore they do not apply to warships, military aircraft, and other sovereign immune ships and aircraft operating in or over the exclusive economic zone. So actually, there are quite a lot of debating, and I think I don't have to elaborate here because Judge Peck has mentioned this in his keynote speech, that we can find out there are a lot of debate and on the different interpretation on the Article 58 of the UNCLOS. For some of them, they argued that foreign ships, especially the foreign warships, they cannot get access to the EEZ to conduct certain activities. However, for other part of the world, for example, for some of the countries like United States, they just insist. For example, the United States mentioned about this. They took the position that the United States has consistently held that the conduct of military activities for peaceful purposes was in full accord with the Charter of the United Nations and with the principle of international law. And I think this issue would talking about the matter about the may cause adverse effects on the environment just because of the military activities. For example, sonar, underwater detonation, and acoustic acoustic test. That would have a very serious impact on the environment. Therefore, military activities in the exclusive economic zone would have another impact on the issues of the environmental protection. Therefore, we can understand that there will be a lot of issues concerning this kind of matter. And now we have to turn to another issue that is about the freedom of navigations. I would like just to briefly mention it in FONUPS. And FONUPS was exercised by the United States. It was declared by the President Carter in 1979. And the purpose for exercise FONUP just want to challenge the excess maritime claims by other coastal states. Of course, if we trace back the development of the FONUP, we can understand that this is a kind of self-protection measure from the United States. However, in nowadays, especially in the recent years, when we look at the disputes happened in the South China Sea, we could understand that probably this will be the source of the conflict between United States and China. I made a study to study about the different state practices for the Asian countries. I think this could be the model for further research for every coastal states of the world. But in Asia, those countries, they are located in Asia, and they have the different practices about the warships enter into their territorial sea. And there are three kinds of state practices. The first kind is they need prior permission or prior authorization. That would be China, Bangladesh, Iran, and Sri Lanka. And for the prior notice and the prior notification, in other words, you just tell us, I mean, for the foreign warships, if you want to enter into my territorial sea to exercise your right of innocent passage, you just give us a note. That's all. And those countries who exercise this kind of practices is the Republic of Korea, Taiwan, Malaysia, the Philippines, Vietnam, and India. And however, there are very little country, for example, like Japan and Thailand, they don't need any condition. You can come to our territorial sea or live, and without prior notification or prior authorization, which is similar to the United States. So from the state practice in Asia, we could understand that probably for most of the countries, they will be challenged by the United States FONAP. And let's look at the, for the past about 10 years, the United States exercised the South China Sea FONAP and also the Taiwan Strait Transit. And we could find out actually it is quite a serious situation because United States use the FONAP as a kind of tool to challenge other country. In some words, they would just use this tool to challenge the excessive maritime claim. However, it will be also a kind of a tool to challenge other countries' jurisdiction or their domestic laws. So this is Taiwan Strait. Let's talk about some of the issues in the Taiwan Strait. This is Taiwan Strait, and I quite like this map. I found out this map from the internet because it shows the baselines from Taiwan and mainland China, also the width of the territorial sea. So if you look at this map, the area surrounding Taiwan, the light blue area is the internal waters. And outside of internal waters, there is a belt of the darker blue area. That is the territorial sea. And on the other side of the mainland China, that you also can see the internal waters as well as the 12 nautical miles of the territorial sea. So in between, that is the Taiwan Straits, and also that belongs to the overlapping area of the exclusive economic zone claimed by Taiwan and mainland China. The narrowest distance between Taiwan and mainland China in the Taiwan Straits is about 70 nautical miles, and the widest is 97 nautical miles. Therefore, if we take off the 12 nautical miles from two sides, we still can find the exclusive economic zone in between. And also there is a median line in the middle, in the center or in the middle of the straits. Have a very brief history of the median line in the Taiwan Straits. Actually, it was created by a United States general in the 1955. And from the very beginning, this median line was to restrict Taiwan's, flights and also Navy ships to come across and then to go to westward to the Chinese coast. And when I studied this, I found out that this is very similar to the northern limit line between South Korea and North Korea. And actually this line, this median line in the Taiwan Straits doesn't have any international meaning. And it is just a kind of created by the, by the United States, and also for the for the almost 50 or 60 years, it was just followed by Taiwan and mainland China. So now the question is like this. China's foreign ministry spokesperson Wang Wenbin, he expressed at a press conference on 13th June 2022, this year. Obviously, he is challenging the international waters, the term of international waters used by the United States. Let's look at what Mr. Wang, he mentioned, especially for the first point. He said, in China's view, the concept of international waters does not apply to Taiwan Straits because it has no legal basis. That is what I mentioned about the median line. In the international law of the sea, this is a challenge to the term, obviously, to the term that international waters claimed by the United States. He continued to mention that the waters of the Taiwan Strait, extending from both shore towards the middle of the straits, are divided into several zones, including internal waters, territorial sea, contiguous zone, and the EEZ. China has the right about the sovereignty, sovereign rights, and the jurisdiction. So, I mean, the Chinese side, actually, they mentioned this quite clearly, and probably what Mr. Wang mentioned in June would give us some kind of hint to think about. And there are actually 4 kinds of crises happened in Taiwan Straits. 1950s, and there were 2 in 1950s, and another one in 1990s, and the latest one is in August this year. And especially in this year, the Chinese military exercises began on August the 3rd, 2022. This year initiated the 4th Taiwan Strait crisis. The most immediate reason for the exercise was just because the United States Congress House Speaker person Nancy Pelosi's visit to Taiwan. Now, this is the map showing the military exercise or drill surrounding Taiwan. There could be 6 parts. And I put the number on it so that we could easily to mention. Obviously, area number one, that is in the middle of the Taiwan Straits, and actually cover on the median line of the Taiwan Straits. Obviously, the first, of course, they want to do the like a bomb shelling, and another thing is just want to prove that the median line of the Taiwan Straits does not exist. And for the area 2, 3, and 6, it's not only on the exclusive economic zone, but also on the in the internal waters of Taiwan. So basically, it was a really dangerous situation, and also I would like to say this will be a kind of exercise of the Chinese political will, and probably I have to draw your attention to the area 4. Area 4, that is quite an awkward situation, because that area not only in the Taiwan's exclusive economic zone, but also in Japan's exclusive economic zone. In other words, China's military exercise or military activities happened in the overlapping EEZ. So what is going to be solved? That will be the one of the questions that I want to raise for the unsolved issue. This map shows the very latest development and actually the very latest military exercises by China or between China and the United States. The United States sent out the Poseidon P-8A helicopter through the Taiwan Straits, but very close to the Chinese territorial sea. According to the reports, it is only 13 nautical miles from the baselines, from the Chinese baselines. So this would create another problem and scenario. And also, in the same time, China sends out 27 aircrafts and also 4 marine fleets in the Taiwan Straits to monitor the flying of the United States airplane. So this comes to the conclusion. A very possible scenario could be happened. Why I say so? Let's look at the China Maritime Traffic Safety Law in last September. Article 120, it mentioned that especially for the second sentence, on the last fourth line, it says that the relevant laws shall be applicable to the administration of foreign military vessels within the sea area under the jurisdiction of the People's Republic of China. So what about the definition of the sea area under the jurisdiction of the People's Republic of China? I found out the answer. The answer is in 2016, the Supreme Court mentioned about this. He says that for the purpose of this provision, sea waters under the jurisdiction of China shall refer to the inland area, territorial seas, contiguous zones, and exclusive economic zones and the continental shelf of China, as well as the other area water, other sea water under China's jurisdiction. So the possible scenario would be like this. How about China enforce its maritime traffic safety law against the navigation passage of the United States warship through Taiwan Straits, especially when the United States warship did some kind of military activities? So that will be another issue, could be solved by the state practices. Also, probably would raise another round of another round of debate on the different interpretation of the UNCLOS. So that is my presentation today, and thank you for your listening. Thank you.
I thank Professor Wang for his insightful presentation. He addressed different interpretations on military activities in the EEZ. He also dealt with FONOPS and its implications, and the 4 Taiwan Strait crises. Now I turn to Professor Susan Laronde for her presentation.
Hello, everyone. I would also like Your Excellency, distinguished colleagues, I would like to extend, I think there's one, is it still on our desk? I don't want that noise the whole time. Yeah. I'd also like to extend my warmest thanks to Director Park for his very generous invitation to KMI and the Korean Ministry of Oceans and Fisheries. It's a real honor to be participating in such an important meeting and with such distinguished experts. I'd like to use my time to discuss situations where foreign military exercises clash with fishing activities in the exclusive economic zone. And I'd like to focus specifically on one type of military activity, live fire drills or trials, because that's easier and less controversial. And so, yes, I deliberately went that way. We have heard, by live fire, I mean military drills or exercises in which ordnance or artillery and live ammunition are used to create training conditions that are as close to real combat scenarios as possible. A clash of this type of military, these live fire drills, and fisheries activities was present in two incidents which I have chosen to help illustrate my arguments, because that's all they are at this point, arguments. The first incident I've called the Alaskan incident, which occurred in 2020. In late August of that year, in 2020, the Russian Navy ran a military exercise known as Ocean Shield. It involved about 50 warships, 40 aircraft operating throughout the Bering Sea. Now, some of the trials were held inside the US EEZ, and definitely, most definitely, had an impact on American fishing vessels and their crews. One example, and this is, there are different accounts of what happened during those days, but one of the most vocal was the captain of the American fishing vessel, the Northern Jaeger. As described by the captain, the vessel was ordered out of a very productive fishing area, and they had just arrived and they were getting going and really happy with the fish they were able to catch. They were ordered out of the area first by Russian military aircraft and then by two different vessels, Russian vessels. And for me, actually, very stunning. We're told not to return to those lucrative fishing grounds for 9 days. 9 days. Captain Thomas, in speaking with the New York Times, estimated that the forced departure from the area probably cost his company more than $1 million in lost revenue. U.S. officials confirmed that a Russian submarine did launch a cruise missile from the Bering Sea on the day the Northern Jaeger was instructed to leave. I just mention it because this is therefore a scenario of a live fire drill, and also how dangerous it was for the fishing vessels in the area. Interestingly enough, American government officials stated formally that the Russians had a right to transit the U.S. EEZ. Fine, okay, that's okay, we'll come back to that. The next incident is much more recent. In January of this year, the Irish incident. I'm very descriptive here. So 20th of January 2022, Russian naval drills are announced for the 3rd to the 8th of February in a sector within Ireland's EEZ. Now, Ireland's Department of Transport went so far as to issue a marine notice stating that the Russian exercises would include the use of naval artillery and the launching of rockets, and so fishing vessels should clear the area. If you read around the accounts, Irish fishermen, Ireland's government denounced publicly and vocally the Russian exercises, insisting that important fisheries and marine wildlife would be negatively impacted. So real concerns about noise, pollution, and also just impact on fisheries. Again, I was intrigued the last, oops, sorry. Oh, it didn't advance, I'm sorry. I'm very sorry. again, I was very interested in the response by the official government response. So Ireland's Minister for Foreign Affairs and Defence publicly declared that the Russian exercises were neither welcome nor wanted, fair enough, but claimed that Ireland did not have the powers to prevent the exercises from happening. Now, ultimately, and a lot of the credit is given to the Irish fisheries organizations who met with the Russian ambassador, but lo and behold, the Russian government eventually released a statement in which it expressed it as a gesture of goodwill, out of the goodness of good neighborliness. It would relocate the exercises outside the Irish EEZ. And I find it interesting that they made a point of saying so as to, with the aim of not hindering fishing activities by Irish vessels in traditional fishing areas. So I think a bit of an acknowledgement there that there would have probably been, most likely, very certainly an impact on fishing. All right, here we go. So, issue number one, slightly controversial. So here we go. My statement, I think the use of naval artillery or the launch of rockets or missiles, so these live fire drills, within a coastal state's EEZs are not a high seas freedom brought into the EEZ regime by Article 58 of the LOSC. Now, I'm not saying, I'm very specifically focusing on live fire drills, not military activities in general. I would not like to run counter to Director Park's excellent article he published. And in fact, I would argue, well, it's a little controversial, but I think even this classic US position, notably when the message from the President of the US when transmitting the Law of the Sea Convention, talking about these historic activities that were covered by Article 58. I would argue, but it's an argument, that there are different types of military activities. I was so grateful to Judge Pake's presentation this morning. I hope I stay within what he might find reasonable interpretation of 58 paragraph 1. On different issues, I find we're confronted with the idea that, yeah, well, during the negotiations, this is what we were trying to accomplish. This is what delegations wanted. But in the end, 40 years later, we have specific legal text. And 58 paragraph 1 is specific. As was mentioned by Judge Pake, what is provided for are certain freedoms. Freedom of navigation, overflight, submarine cables. I'm going to focus on navigation, if you permit. And so the freedom of navigation, fine. And then, of course, other internationally lawful uses of the sea that are related to those freedoms. So other international lawful uses of the sea related to the freedom of navigation. And on top of that, 58 paragraph 1 says, and the exercise of these freedoms has to be compatible with the other provisions of the convention. I would argue that 58 paragraph 1 makes it clear that it doesn't logically follow that an activity that is legally permitted on the high seas is automatically permitted in the EEZ of a coastal state. At least, and I would submit, not all military activities. I'm sorry, the text is a bit small. So here's the pitch. Live fire drills, that is launching of missiles, rockets, use of artillery, as opposed to, for instance, formation maneuvers between naval vessels. That live fire drills are not the exercise of free navigation, are not connected with the freedom to sail ships, which is how the right of navigation is defined in Article 90. Nor is the, and I'm repeating just to emphasize, nor is the launching of missiles or rockets, the use of artillery, and international lawful use of the sea related to the freedom of navigation. These are not activities, I would submit, intimately connected with the operation of ships. Now, this could be slightly controversial, but I would submit, I take some comfort from the separate opinion of Judge Vukas in MV Saiga. Of course, we were talking about bunkering other issues. I would agree, having read Professor Hayashi's fantastic article, that and he takes a moderate position, because of course we have, and perhaps we should prone a moderate position. It's not no military activities are permitted, all military activities are permitted. Professor Hayashi comes to the conclusion, looking at state practice, that perhaps naval exercises of reasonable scale without the use of weapons are permitted in EEZs or can be considered part of the freedom of navigation. All right, that was, I can understand that first issue, or my first arguments might be controversial. I think this number 2 is actually not as controversial, and I don't think it should be controversial. And this is even, because this is easier. Where foreign military live fire drills have an impact or threaten marine living resources, here I would argue that the coastal state's sovereign rights over resources guaranteed by Article 56(1)(a) take precedence. So, my approach here, and I'd like to take 2 prongs, and hopefully I can be clear about this. Often when we're discussing, and I think it's been mentioned today already, when we talk about naval activities, military activities in the EEZ, we will mention a clash of interest, a clash of rights. Who should take precedence, a coastal state or foreign states? I think, though, we have a problem here where living resources are impacted. I don't think Article 59 actually comes into it, but it's kind of tied to my first argument. Article 59 only comes into play, the idea that equity will balance the conflicting, the clashing interests, if neither parties can point to a right that is assigned to it, that is allocated to it. Now, having argued that live fire exercises are not part of the freedom of navigation allows me to argue that, well, there is no clash of interests. There is no actual right given to other states to conduct live fire drills, whereas the convention very definitely recognizes sovereign rights over the management, conservation, etc. of living resources to the coastal states. So I would say that there is no conflict of interest or activities to be resolved. Here, the sovereign rights trump. But I want to be fair. I want to try and what if I'm wrong? What if I was wrong with my first argument? What if the US position is the right one? That is to say that live fire, like using ammunition, rockets, missiles, weapons launches, are part of the freedom of navigation, because that changes, or could perhaps change, because then you would have that clash. You would have freedom of navigation versus sovereign rights over living and other resources. So I thought, okay, I need to think about that in case I'm wrong. But I still think coastal state rights will take over. Because in this case, you see, I think in this case, now we come into Article 58, paragraph 3, and this due regard that was mentioned earlier. In exercising this freedom of navigation, which I really don't believe includes these live fire exercises, but a foreign navy is told must have due regard to the sovereign rights of the coastal state, and even has to comply with its laws and regulations. And again, this time I would turn to Judge Lang's separate opinion in Saiga. He was very clear in his separate opinion that in exercising their freedom of navigation, foreign naval vessels cannot encroach on specific and clearly identified coastal state rights as defined by the Convention. I wholeheartedly agree with Professor Natalie Klein when she writes in her paper that when weapons are involved, you're shooting artillery into the waters above rockets, the interference with the coastal state's sovereign rights over marine living resources is almost inevitable. And therefore, if it's almost inevitable, it will encroach on the clearly identified rights of the coastal state. And I chose fishing rights. I told you I took the easiest case, even over pollution. A coastal state has jurisdiction over marine pollution. We're talking about sovereign rights over marine and living resources and others. And I think, just going back to this idea about weapons and this encroachment, I think this is the path forward. This is commanded. This is an interpretation that flows from this precautionary principle. And I didn't want to get into a big debate whether it's a legal rule, an international standard. I think the precautionary principle is accepted and demands caution. And if that is true, then I would argue that the firing of weapons, the use of artillery will, in almost all cases, be deemed to potentially have some detrimental impact, whether it's noise, pollution on fisheries and other marine living resources. And for this reason, I think those activities should be reserved for high seas areas. And then last issues, but much faster. Here, I don't think this third proposition is controversial. Well, I was just so comforted to find, I mean, if Professor Van Dyke says it's so, then that's good for me. Exclusion or warning zones in the EEZ are unlawful. I'm referring here to the Russian Navy commanding that an American fishing vessel should clear out of an area in the US EEZ for 9 days to create, therefore, an exclusion zone while it ran its military exercise. 9 days. Now, I'll just quickly go through this. These are our last two slides. This is an article that goes back to 1991. Professor Van Dyke looked at whether it was okay, it was lawful for some major maritime nations to declare exclusionary or warning zones on the high seas for military purposes. And in looking at the high seas, he came to the conclusion that, I'm jumping, a wonderful article, that such zones, creating these zones, excluding others, were only lawful if they have no appreciable effect on navigation and do not interfere with fishing activities. This conclusion, I'm paraphrasing a wonderful argument he builds in this paper, but it flowed from essentially the obligation, again in 87-2, talking about freedoms that have to be exercised with due regard to the interests of other states. And from this, I found it fascinating to read that in Professor Van Dyke's opinion, a vessel that entered such a zone on the high seas could not be forcibly removed from the area, except with the consent of the flag state. And if also the vessel was operating with the support of its flag state and was damaged by the military activities, then there would be liability. And of course, damage, we're thinking physical damage to the vessel, but I just wondered about economic damage, thinking back to the captain of the Northern Jaeger and his 1 million loss in revenue, in any case. So just to conclude on that point, Professor Van Dyke's analysis and conclusions, if they hold for the high seas, they definitely, if not more so, are valid in relation to the EEZ. And so I think Russia could not exclude American and Irish fishing vessels in the US and Irish EEZ. So here we go. Last slide. So my conclusion, is it controversial? I await your questions. I'm a little worried, but I think the United States and Ireland could invoke some legal arguments to justify preventing the Russian live fire drills in their EEZ. Thank you very much.
I thank Professor Laronde for her outstanding presentation. She analyzed the case of live fire drills and the use of naval artillery having detrimental impact on fishing activities and other marine living resources. She quoted Professor Van Dyke's conclusions, namely exclusionary or warning zones on high seas are only lawful if they have no appreciable effect on navigation and do not interfere with fishing activities. I personally appreciate her view or conclusion that Professor Van Dyke's conclusions are also valid in relation to EEZ. Now I give the floor to Professor Kim Hyun-jung.
Thank you, Chairperson. First of all, I would like to express my deep gratitude to the Korea Maritime Institute and the Ministry of Oceans and Fisheries for this kind invitation. I'm very honored to discuss in the second session under the chair of distinguished Professor Hee-kwon Park. And I'm also very pleased to meet the three speakers. We are all here to discuss military activities in the EEZ. It was interesting to listen to the three presentations about this issue. The three speakers led with this issue from different perspectives, although this is the same issue. I'm very grateful to all three speakers for their insightful and informative presentations. UNCLOS has a few provisions explicitly referring to peace and military activities. Article 301 concerning peaceful uses of the seas is the provision applicable to all maritime zones. It is interesting to note that the content of Article 301 follows Article 2, Paragraph 4 of the UN Charter. As shown in the negotiation history and the third conference on the law of the sea, states had different point of views on peaceful uses of the oceans. In the sense, it must have been a reasonable compromise to rely on the wordings of Article 2, Paragraph 4 of the UN Charter, which are generally accepted. On the basis of the provisions of UNCLOS concerning peaceful uses of the oceans, we can conclude that not all military activities are prohibited. Military activities may be conducted at sea, including the foreign EEZ, unless they are incompatible with the UN Charter. Of course, other conditions may apply as well, depending on types of maritime zones. Professor Wang and Professor Lalonde discussed the identification of conditions for military activities to be permitted in foreign EEZ. In particular, as Professor Lalonde addressed, I consider that the states should comply with Article 58, Paragraph 1 of the UNCLOS to justify their military activities in foreign EEZ. In addition, Professor Wang commented upon state practice on foreign worship and right of innocent passage. For example, the Republic of Korea, as Professor Wang addressed, the Republic of Korea requires that foreign warships notify before entering its territorial waters. I consider that such requirement for prior notification should be distinguished from prior authorization. Considering the considerable level of risk of a proposed system of ships, such as nuclear-powered, we can say that it is necessary for the coastal state to be aware of such ships' navigations in advance. Therefore, the requirement for prior notice or prior notification can be considered as a reasonable action for the safety of navigation or national security without significant prejudice to navigation. Furthermore, Professor Wang commented upon the freedom of navigation operations, FONOPS, exercised by the U.S. U.S. naval vessels sail through contested waters in the name of FONOPS to protest against other states' alleged excessive maritime claims. For example, U.S. naval ship Charles Drew carried out the freedom of navigation operation in the vicinity of Gukdo Island, close to Tongyang, Gyeongsang-namdo, South Korea in March 2021. The U.S. first announced that this operation was performed to challenge Korea's alleged excessive strait baseline claim. I consider that FONOPS can qualify as exercise of navigational right or freedom, although their purpose is to protest against other states' claims rather than to navigate. For this, of course, the naval vessels engaging in the operations should comply with the regimes of navigation in each maritime zone and 1972 Convention on the International Regulations for Preventing Collisions at Sea, for example. Then also, I would like to make the brief comment on China's maritime traffic and safety law, as Professor Wang commented. I agree with Professor Wang's opinion that the concept of sea areas under jurisdiction of a PRC is a very contentious and ambiguous concept. However, I would like to highlight as well that according to Article 121 of China's Maritime Traffic and Safety Law, the treaties that China is bound by prevails over maritime traffic and safety law in case of conflict between two. So, of course, we can say that we might have a different point of view on the concerning the interpretation of treaties. But however, I would like to say that at least China expressed officially that its intention to comply with the treaties that they ratified. Moving on to Professor Kunoi's presentation, I found that Article 298, paragraph 1b of UNCLOS is established to take into account the sensitivity around military activities. This provision provides for military activities exception from compulsory jurisdiction of international courts and tribunals established under Part 15 of UNCLOS. As Professor Kunoi addressed, international courts and tribunals had some opportunities to interpret Article 298, paragraph 1b, or identify military activities under UNCLOS. I would like to make some comments on the basis of relevant case law. First, as Professor Kunoi addressed, Article 298, paragraph 1b excludes disputes concerning military activities from compulsory jurisdiction. As indicated by the arbitration between Ukraine and Russia concerning 3 naval vessels, the word concerning may narrow down the scope of disputes applied by this provision compared to the broader expressions such as arising from or involving. Furthermore, international courts and tribunals highlighted that military activities exception concerns disputes concerning military activities rather than military activities as such. Disputes subject to this exception do not have to be completely and purely military activities. Therefore, mixed cases in which military activities were engaged can be considered as subject to Article 298, paragraph 1b of UNCLOS. Second, international courts and tribunals considered each party's characterization of activities as a relevant factor rather than a determining factor for the identification of military activities. The objective evaluation of the nature of activities prevailed over the state's characterization of activities. Third, UNCLOS does not provide the definition of law enforcement, and nor does it give the definition of military activities. I fully agree with ITLOS and arbitrary tribunals' finding that we must not distinguish military activities from law enforcement activities solely on the basis of the nature of vessels engaged in activities in question. I would like to say again that the three presentations were very interesting and insightful. Thank you for listening to my discussion.
Thank you, Professor Kim. I thank 3 speakers and the discussion for their valuable contributions. We are now ready to entertain questions and comments from the floor. Who's on first? Okay. 4th row, please. And thereafter. Yeah.
Thank you very much, and thank you for the wonderful presentations on a very timely issue. I have a question for Professor Kunoi. You said that the mere involvement of military vessels may or may not be sufficient to trigger the military activities exception under UNCLOS, and what matters is the subject matter of the dispute and the object for using force. I wonder whether, for the purposes of litigation, is this dependent on how states characterize the object of the use of force, or even the subject matter of the dispute? And let me give you an example. State A is sending a military vessel in the high seas to prevent a drilling vessel by State B from entering an area of the EZ to conduct some drilling operations. And in the process of doing that, it shoots live fire in order to intimidate the vessel. And object, State A says that the object is to enforce our EZ law or to protect our sovereign rights. State B says this is a violation of my own sovereign rights. So it's not per se a military activity. So how would you say we can distinguish between the two?
Yes, Professor Kunal.
Thank you. That's a very good question. As a matter of fact, a similar matter appeared in the Coastal State Rights case. The question arose whether Ukraine was stopped from relying on this particular question. It was stopped from arguing that it was not a military dispute concerning military activities on the basis of its declarations in the General Assembly, etc. The Arab Tribunal took a took a casuistic approach in that particular regard, and I would think that, as to your question, it would depend on which approach you would rely on. If I may say in this regard that I would think if one were to apply the standard established by the South China Sea Arbitration Tribunal, one may think that that particular activity would be a dispute concerning military activities. Whereas others may look at, if we follow the approach of ITLOS in the provisional order, the order and provisional measures in the detention of 3 vessels, it may look at that differently. In that particular case, one cannot exclude that the declarations of the relevant states may have a matter in that regard. Thank you.
Thank you. The next one here. Yeah, I think 5th row.
Thank you, Chair, for giving me an opportunity to raise a question to this session. First of all, I'd like to express my deep gratitude to all the great presentations today. And my name is Huncho, a PhD graduate from the University of Glasgow in Scotland. I'd like to raise one question to the Professor Kunoi about the term of military activities. Concerning the recent jurisprudence about the Article 298 1b, some literature criticized that the tribunals has failed to give a definite definition of what the military activities means. And even some authors raised concerns that due to the lack of clarity of the term of military activities, we cannot rule out the possibility that the state parties would interpret the term military activities in a broad sense with discretion to exclude the tribunal's jurisprudence from certain activities and issues. I can fully understand their concerns, but at the same time, I have some doubts on those criticisms based on 2 points. The first one is that the fact that this term is not used in this convention except within the context of Article 298 1b. So I think that the tribunal simply did not need to give a definite definition about this term beyond the context of Article 298. And in line with this context, and secondly, I think that the only question that the participating tribunals are required to answer, it would be determining when the military activity exception is applicable within each of different dispute circumstances, but not the definition of military activities itself. So in this sense, I totally agree with your argument in your presentation that the meaning of military activity exception, not the military activities itself, has been clarified and carved out by the tribunals and the court. So in this sense, I'd like to ask you your opinion about whether you think that the term of military activities needs to be defined by the tribunals. In other words, whether you think that this term is a definable term within the context of UNCLOS. Thank you very much.
Okay, Professor Kunai, again, you have the floor.
Thank you, moderator, and also thank you very much for this very good question. It is a very complex question and touched upon many matters. I would not think that any arbitral tribunal would seek to have a definite definition of what is a military activity. I would think in particular in the coastal state rights case, the arbitral tribunal referred to the particular circumstances in any given situation that were relevant for the purpose of determining whether the dispute is one concerning military activities. I personally, as you asked my question, I don't know what to stress this too much in my presentation now, but now given that you are asking me, I am inclined to share the approaches of the arbitral tribunal in the coastal state rights case and also of ITLOS in the provisional order, on the order on provisional measures, as to how to define a military dispute concerning military activities, in which the emphasis is looking on what is the real object of the dispute, and in which, to the extent that something is the use of force is ancillary and is not the purpose, is not the dispute itself, I would think the approach is embraced by the ITLOS and the Coastal State Rights Arbitral Tribunal are correct. Therefore, I'm excited to see what the outcome will be of the Arbitral Tribunal in the detention of 3 naval vessels as to the qualification of the shooting of targeted shots has been referred to the merits. But one should add also, before criticizing that too much, that Russia did not participate in the proceedings in ITLOS, and therefore, but it did in the arbitral tribunal proceedings on the preliminary objection stage at least, and therefore the arbitral tribunal may have more information than ITLOS would have had in that particular dispute. Thank you.
Thank you. And I see the gentleman on the 4th row.
Thank you, distinguished moderator. Sorry, my name is David Ong. Thank you. First of all, I'd like to thank all 3 speakers for some very, really excellent, in-depth presentations. I'd like to ask a question, if I may, to Dustin, Dr. Wang, and Professor Wang, and Professor Lalonde, Suzanne. And I hope this question shows that, as any good lawyer should be able to do, we can possibly take 2 positions at the same time, even though they may be contradictory. So, Dustin, my question to you, given that you gave us an excellent set of examples of Pacific Asia states in particular, state practice, which suggests that they would like to restrict military activities within their EEZs, and given the idea that UNCLOS, especially in its 40th year, is a living treaty, are we seeing here through the state practice, and it's not just Asia Pacific or Asian state practice, but other areas as well, other regions in the world, which attempts to restrict foreign military activities in the EEZ, are we seeing a development here that may in fact constitute a reinterpretation of this traditional freedom of the high seas, especially within the EEZs? So are we seeing a development possibly of customary duty or customary rule, which is at variance to the general freedom? And then, Professor Lalonde, I thank you very much for your presentation. And I'd like to focus on that last issue, or I think the second issue, where you said it was controversial. I think it's not controversial as long as we don't say, for example, that live firing exercises, this is where live firing exercises obviously will interfere with the exercise of sovereign rights over fishing resources in particular. Are we saying, I think you're probably not suggesting that live firing exercises in such a situation is therefore unlawful under international law. Because for me, it turns on how we interpret and the space we give for states to interpret and apply the due regard and restraint from undue interference provisions. Because in the Chagos MPA tribunal, those provisions were regarded as requiring states to enter into consultation and negotiation with each other prior to the activities that may be then considered to be detrimental to the coastal state's interests. So isn't it the case that if a state wants to conduct live firing exercises, it should first enter into consultations with the coastal state where it wants to, whose EEZ is where they want to conduct the live firing exercises, rather than suggest that these exercises are unlawful per se under international law? Thank you.
First, Professor Wang, and then Professor Lalonde.
Well, thank you. Thank you, Professor David Ong, for your excellent question. I think your question concerning the development of the international law and also the interpretation on the certain convention. Well, I think this kind of issue concerning the different interpretation on the written text of the convention. And this kind of discussion definitely concerns with the different national interests. Therefore, we can see that probably most of the, well, sorry, I don't mean most of the countries. I mean a lot of countries, they agree with that kind of restriction. However, for those maritime powers, definitely they don't like this. So if we come back to the development history and also the discussion in the third United Conventions on the Law of the Sea, Conference on the Law of the Sea, and we could recognize that it is really difficult for me, and for the time being, it is really difficult for me to answer your question. However, I think this kind of debate and also discussion will continue to be continued for I think a couple of decades, probably. Thank you.
Thank you very much for that question. Very quickly, I would just say that you're right to. I hope I didn't say unlawful, but I think fantastic to bring it back to Chagos and the duty to consult. It's just like in the Irish case, the Irish government was pretty clear. No, don't. Unwelcome, unwanted. And so it's just that, you know, at one point, so they notify. We're still stuck with, so is there anyone with precedence? So what if the coastal state doesn't want it even after we discussed and you've notified? And so I think, so you're right to call me out on it, so I'm going to have to go out on a limb and say, yeah, and I think in a case like that, the coastal state will take precedence. It's sovereign rights, but like I said, I love to be able to discuss this with the people in the room, so please, I'm open to a lot of criticism and maybe a better way to formulate it. I'd appreciate that.
Thank you. Next question will be Judge Beck.
Thank you, Ambassador Park. I don't know whether it's a good idea for me to join this discussion, but I want to make one observation about this very interesting presentation on live fire exercises, not because I disagree with what has been said, but just to think a little further. I'm not in position to say whether or not such exercises are included in the scope of Article 58. Instead, I may proceed on the basis of two scenarios. First scenario, maybe relatively easy. That is, if such exercises are included in Article 58, then still states must carry out such exercise with due regard to the rights of coastal state. Then next scenario may be a little more difficult. If such exercises are not included in Article 58, then such exercise, I think the point raised by the previous speaker is an excellent point. I don't think such exercises are necessarily or automatically unlawful or prohibited, just you have just mentioned. I think that is the question of residual activities, activities which are not specifically allocated either for coastal state or other states in the EEZ. Then such activities may be carried out as a residual activities. But then if there is conflict between such activity and the rights of coastal state in terms of conservation of living resources or protection of marine environment, then this is a situation where coastal state has sovereign right under Article 56 on the one hand, and the other states do not have a specific right under the convention, but other states may be permitted to carry out that activity because it was not prohibited. Then I don't know whether this is a situation where due regard obligation would apply. Maybe not. This is a situation where maybe coastal states have a priority because it has sovereign rights over these activities carried out by other states. But at the end of the day, I wonder whether there is any material difference between these two scenarios. In the first scenario, you know, and the second scenario. After all, I think a certain interest of coastal state would be guaranteed under either scenario. But anyway, very interesting situation which we need to reflect on. Thank you.
Judge Beck made a very valuable comment. And Professor Larong, will you respond or no? Okay. Any other questions? Okay.
Thank you, the speakers, for their excellent presentation. In my view, there is a difference between military activities as such and the military activity within the context of Article 290A, Paragraph 1B. As we are all aware, the UNCLOS does not include any definition of military activities. This point has been noted by the international tribunals, including ITLOS and Annex 7 arbitral tribunals. Therefore, we do not know exactly what constitutes military activity as such in a legal sense. According to the book, Excessive Maritime Claims, edited by Ashley Roach and Robert Smith, if my recollection is correct, the United States seems to define allowable military activities in the EEZs of other states very broadly. According to this thinking of the United States, the right to military activities in the EEZ of other states has survived the UNCLOS and remained untouched by virtue of the omission of any express language in it. Such a position of the U.S. may be in conflict with other states. A naval exercise comprising firing of artilleries in the EEZ of other state or in the archipelagic waters of other state may be safely characterized to fall within the boundary of military activities per se. Military activity causing a dispute has been addressed in some cases as dealt with by Professor Kunoy. I wish to ask a question to Professor Lalonde. Just suppose then state A and the state party A and the state party B have not made the declaration on the Article 298 excluding dispute concerning military activities. And my question is it allowed under UNCLOS for state party A to bring state party B to an international court on the basis of Article 58, Paragraph 3 of the UNCLOS when naval exercise on an unreasonable scale without using weapons or using weapons carried out by state B in the EEZ of state B? If the answer is yes, what about the Article 59 of the UNCLOS then? That's my question.
I think Professor Lalonde or Dr. Kunoy.
Yes, so maybe it's better for this would be appropriate for a request for advisory opinion rather than bringing it to contentious proceedings. But joke apart, yes, I would think that to the extent that neither of the parties would have made use of either of the parties would not have made use of the optional exception in Article 2981B. Obviously, the parties would be entitled to trigger the contentious proceedings according to the rules in Article 287. Yet it remains to be seen whether the tribunals would deem that they would have competence to in the dispute in question. Personally, I would think that that would not be nothing that would prevent a court tribunal to exercise jurisdiction to the extent there would be to the extent they would not have been made use of the optional exception. And then whether or not it would be a military activity within the first sentence of Article 2981B, or whether it would be law enforcement, it would be immaterial. So the answer is yes, I would think. Thank you.
Thank you very much. Time is running out, so we have the last question on the third law. Yes, please.
Thank you very much. Can you hear me? I have my mask on. But first of all, my name is Nilüfer Oral from the Center for International Law, National University of Singapore, and I compliment the panel and the commentator as well. It's really interesting, so I very much enjoyed it. And I hate to put you on the hot spot, Suzanne, but actually, I thought you made some really good points and arguments, and I agree with your views, actually, and particularly on the question of when we're talking about protection of marine living resources, even broadly marine environment, and if live fire, and it certainly seems to be not just live fire, certain military activities we know are harmful. That's been established. So rather than the clash of rights per se, but and I think the point you're making about that the conservation interests trump the coastal states' sovereign rights trump, I wanted to draw attention to the case by ITLOS, In re Virginia G. And in that case, and I know we have Judge Paik here, so I hope I'm right. But bunkering, it was about bunkering. And bunkering is considered a freedom of navigation activity. But in that case, because it was linked directly to conservation fisheries, the tribunal found that it could be regulated by the coastal state. My question is this. There are a lot of marine protected areas being established in EEZs. Do you know of anyone that is incorporated in their laws, and it could be part of their conservation laws, including restriction on military activities in these areas?
Yes, please, Professor Lalong.
Much for the question, and actually the answer is no. I'm not aware. It's not that it's no coastal state has done it, and so I appreciate the comment. And I did look at the bunkering issue, so as well I'll go back to Virginia G. So I will note that and look forward to sharing any insights I glean. So thank you for thinking of it, of tying it to the Marine Protected Area dossier. Thank you so much.
I think that will do it for this session. As a result of this session, we have addressed different positions, viewpoints on military activities in the EEZ. We have also addressed several challenges facing us. To summarize, this session is clearly beyond my ability or your patience. But I would say the following as my personal observations. This issue will continue to be a very complex subject without clear definitions in the nature and scope of permissible activity in the EEZ. Moreover, the potential for hostilities is very high, including in semi-enclosed seas, such as South China Sea or East China Sea. Also, as Professor Wang pointed out, the tension in the Taiwan Strait will continue to rise. So I think we needed to promote dialogue among states concerned and form agreements to help clarify the contours of military activities in the EEZ based on mutual interests, interdependence, and coexistence, rather than perceiving the oceans and seas as zero-sum sea areas. We should settle maritime disputes arising from military activities in the EEZ through peaceful means. There is also a need for more extensive supplementation of the UNCLOS on this issue. We need to step up to meet challenges to ensure the UNCLOS continued relevance and vitality for at least another 40 years. With that, let me close this session. Thank you very much.
Thank you. Now we will take a break. Please join us again at 3:40 p.m. 2024. Thank you. 네, 다음 세션 시작하겠습니다. 밖에 계신 참석자분들 안으로 안내 부탁드립니다. If you all take your seats, we can get started. Shall we start? So now we start the session 3. Mr. Vladimir Yares, Director of DOALOS, will moderate this session about the sea level rise and UNCLOS. Mr. Yares, now the session is yours.
Thank you. Good afternoon, ladies and gentlemen. Let me start with thanking the Ministry of Oceans and Fisheries and especially Minister Cho Sung-hwan and the Korean Maritime Institute, Director Park, and the President Kim Jong for hospitality, and for inviting us to this very interesting, engaging conference on issues which are the challenges in the context of the 40th anniversary of the United Nations Convention of the Sea. As you know, the division for which I'm a director operates at the de facto secretariat of the convention, so for us, following developments and views, it's of utmost interest. This afternoon, our distinguished panelists and discussants will address the issue of sea level rise, which comes as part of the adverse effects of climate change, which includes rising seawater temperatures, ocean deoxygenation. Of course, you would probably know that the World Meteorological Organization, in its State of the Global Climate in 2021, highlighted that the past 7 years, from 2015 to 2021, were the warmest on record. And of course, the world also continued to see increasing ocean heat content, rising sea levels, which reached its highest value on record in 2021. And of course, this is caused significantly by shrinking of glaciers and ice on land. The global sea ice shrinking is happening as well, but this doesn't contribute that much to the sea level rise. So of course there is a challenge, especially for the least developed countries and small island developing states, as far as least developed coastal countries, especially in the area of mitigation and adaptation to the climate change impacts on the ocean, including the protection of the coast against sea level rise. Of course, the extreme sea level events and sea level rise are particularly presenting current challenges and existential challenges to small island developing states, as I've said it. Incidentally, the process convened by the General Assembly annually, which is the informal consultative process on oceans and all of the sea, in June 2021 addressed the issue of sea level rise and its impacts and focused on the characterization extent of the sea level rise, on regional variability, its environmental, social, and economic impacts, highlighted the urgency of addressing the impacts of the sea level rise and extreme weather events. And of course, there is an important element of science policy interface. But of course, there is also an appropriate forum working on legal matters that are related to the sea level rise. And in this regard, we have two distinguished presenters today. They'll be presenting, the panelists will be presenting their contributions in a different order. We'll start with Professor Alfred Soens, who is a very known scholar. He studied law at Utrecht University in the Netherlands and followed postgraduate studies in international law at the University of Washington and Cambridge University. He has a PhD of law at Utrecht University with the thesis in the field of oceans on the law of the sea. And of course, he served for many years as a civil servant in various legal and policy positions at the Netherlands agencies, national ministries. Then he became professor of public international law and director of the Netherlands Institute for the Law of the Sea at Utrecht University. While he is retired from the position, he remains active. Of course, he was, among other things, involved in arbitrations and international litigations before the International Court of Justice and arbitral tribunals. The second panelist is distinguished Professor Nilüfer Oral, and she has already been very active during the discussions, who is the director of the Center of International Law at the National University of Singapore. She's also a member of the United Nations International Law Commission and co-chair of the study group on the sea level rise in relation to the international law. And she served as a legal advisor to the Turkish Foreign Ministry for the law of the sea and as a climate change negotiator. In addition to that, she's a distinguished fellow of the Law of the Sea Institute at Berkeley Law and lectured at the Center for International Law. She was lecturing at the United Nations Regional Law Courses for International Law and the Rhodes Academy for the Law of the Sea. She also served on the International Union for Conservation of Nature Council from 2012 to 2016. Was a co-chair of the IUCN Specialist Group of Oceans, Coast and Coral Reefs, and was chair of the IUCN Academy of Environmental Law. And in order to allow sufficient time for the panelists to speak, I'll stop right now, and I'll introduce our discussants after they finish the presentation. Professor Soens, the floor is yours.
Now it's working, I hope. Thank you, Chairman. May I first thank the organizers of the conference for the invitation to participate in this highly interesting conference. I liked very much the extended abstracts included in the program booklet. They make us all very well prepared for the panel sessions, provided, of course, we have read them. I will proceed on the basis that you have, which makes it possible for me to make maximum use of the limited time we have for our presentations. In the abstract, I try to identify the main questions raised by the state practice that my topic is about. I will now only briefly summarize the background of this practice and then the practice, and then discuss the questions I'm raising, but this is only an attempt for me to stimulate the discussion. I am very interested in your views and the comments, of course, from the commentators. So, what is the problem that sea level rise causes for maritime zone entitlements? Well, it's all about baselines, or almost all. Talking about baselines, the normal baseline, you all know by heart Article 5 of the Convention. The question is this normal baseline ambulatory? That's the term that is generally used. I don't personally like the term, but it's a generally accepted term to denote a particular interpretation of the normal baseline, the low water line as marked on large-scale charts. And then essentially the question is, must changes in the location of the low water line as a result of sea level rise be reflected in the chart? This interpretation, when it is reflected in the chart, of course, then that creates the new legal baseline. That's the ambulatory baseline theory. This interpretation of Article 5 was, until very recently at least, generally accepted. That's my understanding. And I think this is demonstrated, in fact, by the concerns of Pacific states that triggered the recent state practice that we will be discussing. That interpretation would cause great problems, in particular for low-lying states and island states in particular. Their maritime zones will shift landwards or can even disappear partly or wholly in case of islands. Apart from the normal baseline, of course, we also have the strait baselines, Article 7, and archipelagic baselines, Article 47 of the Convention, which can be drawn by the states in question in particular circumstances and under specific conditions, all mentioned in Article 7 and in Article 47. These conditions could be affected by sea level rise. And then the question is, would that require adjustment of the baselines? On this issue, I believe there is very little or perhaps even no practice. If anybody here would know about practice relating to adjustments of strait baselines or archipelagic baselines as a result of shifts in the low water line and or in other conditions to draw those lines, I would be very interested in hearing that from you. And then in areas of overlapping entitlements, when there are maritime boundaries delimited by agreement or judicial decision, they remain, at least in principle, unaffected. I come back to that later, but that is a way, of course, to ensure the continued exercise over the entitlements in question. Now, the recent state practice of Pacific Island states. It has three elements: the conclusion of boundary agreements, the fixing of the baselines, and political statements. The first point, many areas of overlapping entitlements have recently been delimited by agreement. I think over 10 or 12 in the past 10 years only in the Pacific area, and this continues. The second point, although the legislation on baselines of most Pacific Island states originally referred to the low water line, recently this has changed into legislation referring to geographical coordinates, defining the baseline. Coordinates based on the current location of the low water line. And an example that I mentioned in my extended abstract is of Kiribati 2014 revised legislation, where you can see a shift from earlier legislation using the normal baseline, the low water line, to a fixed baseline determined by the minister on the basis of geographical coordinates. And several other states in the region have adopted the same practice, and others are following at the moment. The third element of this state practice are the political declarations. In different fora in the region since 2009, the states there have taken the position that the newly defined baselines will remain in place notwithstanding future changes to the low water line, and that international law does not require them to amend their legislation after such changes. I note here that this approach is along the lines of the recommendations adopted by the International Law Association at the Sydney Conference in 2018. There's now a refusal of technology to proceed to the next slide. Somebody is interfering. We don't know. Oh, well. And this practice of political statements declarations in the Pacific region culminated last year in August, when the leaders of the Pacific Islands Forum issued the Declaration on Preserving Maritime Zones in the Face of Climate Change-Related Sea Level Rise. And in this declaration, they proclaimed that their maritime zones, based on baselines and outer limits established in accordance with the Law of the Sea Convention, as notified to the Secretary General of the UN, would be maintained notwithstanding the effects of sea level rise. The declaration, interestingly, also affirmed the view that the Convention imposes no obligation to keep baselines in general, not only the normal baseline, and outer limits of maritime zones under review, nor to update charts or lists of geographical coordinates once deposited with the Secretary General of the United Nations. So, no ambulatory baselines anymore, according to the Pacific states. Not only in the Pacific region, but also in the rest of the world, you can see some changes occurring. States have taken positions, at least in policy statements, and that is the result of the involvement of the International Law Commission, which started in earnest in 2019. Many UN member states have submitted information on their practice to the Commission, and at debates in the 6th Committee of the General Assembly, they have expressed their views. And I think we can note that in general, states have expressed from all regions of the world support for ways to prevent loss of maritime entitlements due to sea level rise, although there are some divergent views on exactly what is the current law and on the solutions. And very significantly, the United States, not a party to the convention, stated last October at the 6th Committee discussions that it recognized this new trend in state practice that I just referred to, and that it will not challenge, and the United States is very good, very well known about challenging, will not challenge lawfully, and that is of course an interesting word here, lawfully established baselines and maritime zone limits that are not subsequently updated despite sea level rise caused by climate change. This looks very much like the United States is in fact supporting the Pacific Forum statement of August last year. Now, unless one adopts an interpretation of the Convention's provisions on baselines that already allow this fixing of baselines and maintaining them notwithstanding future changes in the low water line, the new practice, almost entirely limited to the Pacific region, deviates from the current law of the ambulatory normal baseline. But all signs indicate that states are willing to adapt the law to prevent loss of maritime entitlements through sea level rise. But how do we determine if a change in the law has happened? I think personally that we are witnessing a highly interesting, rapid development, change, if you will, of the law, reminiscent of the continental shelf regime developing in the years immediately following, in 1945, the Truman Proclamation on the continental shelf. Oh, come on. Yeah. Change of the Convention's provisions through their application would lead to a new interpretation. And as we all know, Article 31, Paragraph 3 of the Vienna Convention on the Law of Treaties states that in interpreting a treaty shall be taken into account A and B, I come back to A in a moment, first B, any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its application. Another approach would be to construe an agreement on the new interpretation. That's Article 31, paragraph 3a. Any subsequent agreement between the parties regarding the interpretation of the treaty or the application of its provisions. Maybe the... No. But, and now I come to a series of questions. What exactly would be the new interpretation through practice or agreement? Probably something like that the normal baselines once established by the coastal state in accordance with the UN Convention may remain in place notwithstanding subsequent changes to the low water line. But is this only due to sea level rise, as we have seen in all these statements, also what the US said last October? I think in practice it would be almost impossible to distinguish between changes resulting from sea level rise or from other geological or geophysical processes. So perhaps we should better talk about subsequent changes to the low water line in general as a result of physical developments. Only baselines that have been fixed and notified to the UN Secretary General, would that be a new condition, which is new for the normal baseline because there's no provision in the convention referring to the normal baseline being the charts being sent to the deposited with the UN Secretary General? Should there perhaps be a sort of a vetting process for such submissions? And would it also mean that strait baselines and archipelagic baselines also need not to be adapted if they no longer conform to the current conditions of Article 7 and 47? The statements so far by the Pacific states, but also the recent US statement, point in that direction, that all baselines are included, which personally I think would be the only way to deal with this issue. So my question is, have all consequences of the current emerging practice of fixing baselines and outer limits, both, been fully examined? In particular, this question of the consequences of fixing baselines rather than outer limits, or both, may result in practice in potentially large enclaves of territorial sea and internal waters remaining within exclusive economic zones. Of course, this is possible. The question is if it is desirable in general. And another question to look closer into is, in case of agreed and adjudicated boundaries, the issue of sea areas which have become located beyond 200 nautical miles of either state's baselines as a result of sea level rise. Is the doctrine of the finality of agreed boundaries deficient also vis-à-vis third parties? I think these two aspects should be discussed in more detail by ILC, ILA, to get clarity about exactly what would be the new regime. For lawyers, of course, the interesting question is when would the desired, obviously desired, change of the law have taken place? How general must the practice have become? How significant is the absence of objections by other states to this practice? I think definitely not all states, all coastal states need to be involved, but many in different regions to talk about a general practice. And the absence of protest, I think, is very significant in this context, since all states in the world by now should really be on notice and know what is happening and to which they could object. Similar questions arise about a change to the rules of customary international law, which in any case requires the involvement of non-parties to the UN Convention. Is it possible to have different rules on this issue under the UN Convention and under customary international law? I would say in theory, yes, but in practice, it seems to be, to me, no. So, finally, to get clarity, if a formal amendment to the convention or the adoption of a separate legally binding agreement to this effect is an unrealistic option, if that is true, which I think it is true, perhaps for the purpose of legal clarity, it would be better to strive for a resolution of the UN General Assembly adopted by consensus, or perhaps even better, unanimously, laying down the new rules in some detail, for which, of course, it would be necessary that is well prepared with negotiations, etc. Could that resolution then reflect the subsequent agreement meant in Article 31, paragraph 3a of the Vienna Convention on the Law of Treaties, and at the same time the opinio juris for the creation of new rules of customary international law? And these are the questions, I think, that we may discuss further today, tomorrow, and the coming period. And I look forward to your comments and further suggestions. Thank you for your attention.
I would like to thank Professor Thorns for presenting us with a number of challenging questions and issues. Of course, to those questions would be, of course, I would perhaps add a couple of other, for instance, what about the principle land dominates the sea, which is part of the convention, the logic of the convention, that in order to possess maritime zones you have to have island, some territory, and of course the Article 121 comes into play very significantly in relation to some maritime zones. Of course, the issue of vetting is a very interesting question, and so far there is only one vetting process in the context of the Law of the Sea Convention. This is the one relating to the delineation of the outer limit of the continental shelf beyond 200 miles, for which you have the Commission on the Limits of the Continental Shelf. But even in that case, the baselines which are required and necessary for the distance-based formulas and constraints, they are taken at the face value. And of course, the whole technical aspect of the Law of the Sea Convention, especially in the light of rapidly evolving technology, raster charts being replaced by electronic nautical charts, which are actually reflecting the real-time challenges, and then might be also in terms of safety of navigation, shifting of position of low tide elevations. Some of them might shift after extreme weather events and present challenges to navigation. So these are very interesting issues. But I don't want to encroach on Professor Oral time, so please, the floor is yours now to address a second topic under this panel, under this session 3. Professor Oral, over to you.
Thank you very much. And I apologize, I may stay here because I need to see the PowerPoint. I'm not sure I can see it from there. Can you? Yes, you can? Okay. Okay, thank you. Of course, first of all, I begin by expressing my sincerest appreciation to KMI and the Ministry of Oceans and Fisheries, and particularly to Director Park for all his hard work and for bringing us together in snowy Seoul. It's beautiful. And I'm coming from tropical Singapore, so it's quite a difference. To be with such distinguished colleagues, I'm truly honored. And it's also an additional honor to follow Professor Soon, someone whom I admire greatly and has done so much work on this issue. And I don't mean to date you, but you are really one of the pioneers of this issue. So really, I have to acknowledge that. All right, so I'm going to be looking at Well, actually, I changed the title, but I had a slight problem with my PowerPoint. But basically, I'm looking at a specific issue that maybe not be quite as open to state practice, and that is the issue of islands, sea level rise, and sinking islands under Article 121 in particular. All right. All right. So first of all, the question of islands, definition of islands, their entitlements, this issue's been around for a long time, dating back at least to the 1930 Hague Conference. It was debated, and basically we've adopted the definition that was given back there. It's a naturally formed area of land surrounded by water and permanently above the high tide mark. The question of entitlements of islands, however, was not settled. Although when we look at the 1958 conventions, islands are included in relation to territorial sea and the continental shelf. But really our focus right now is on the 1982 Law of the Sea Convention. And again, key to the definition, naturally formed, surrounded by water above, which is above water at high tide. But the big question is on the entitlements. Article 121 provides islands with all the entitlements: continental shelf, territorial sea, exclusive economic zone, contiguous zone, unless, and this is the what I call a very cryptic provision, the famous paragraph 3, rocks which cannot sustain human habitation or economic life of their own basically get just a territorial sea. Low tide elevations get nothing. But to be quite honest, what does that mean exactly? There's very little guidance. Anyway, I thought I would throw in some nice pictures when you're talking about islands. And we see they can be very ephemeral. I mean, here we have an island that seems to have some human habitation there. And I just wanted to say, too, that the Commission, as Professor Sins mentioned, the study group was established. This is the first issues paper that was prepared by myself and my co-chair and colleague, Bogdan Orescu. And this is one of the issues we looked at: possible legal effects of sea level rise on the status of islands, including rocks, and on the maritime entitlements of coastal states with fringing islands, and also the question of artificial islands, including artificial means of preservation, land reclamation, etc. So I'm going to try and basically go through these issues. And here I borrowed a PowerPoint from Clive Schofield, which is animated and shows you, the low tide, high tide, and how the island rock distinction is made. Now, the question is, I said, paragraph 3 is very cryptic, but what it makes clear is that under certain circumstances, an island will be a rock. So it may be above water at high tide, but if it's unable to sustain human habitation or an economic life of its own, it will be a rock. Well, what does that mean? For sea level rise, because we know that sea levels are rising, it's happening, there's already been some loss, but one of the big issues are people are no longer able to live on islands they've inhabited for generations. Why? Not simply because they're losing territory, that's part of it, but also fresh water supplies are being infiltrated with salt water. They're unable to do agriculture. So the question is, does that turn a once habitable island that's capable to support economic life of its own into a rock? And of course, if it loses territory and is no longer above high tide, then what happens? Then it's a low tide elevation. So it's a question of preservation or devolution. Does an island devolve into a rock or a low tide elevation? And again, an example of what that means in terms of loss of ocean space, and we know why for the Pacific Islands it's so important. small island states or large ocean states. They have vast areas of exclusive economic zone. So I didn't do the calculation. This is through an expert. But a small island, under certain circumstances, could generate up to over 400,000 square kilometers, whereas a rock would be down to about 1,550 square kilometers. So it may be an extreme, but it does show you what it could be. Well, what about the case law? So Article 3 and the Travaux Preparatoires really doesn't give us much guidance. The question of island entitlements was somewhat debated, and I come from a country that still to some degree challenges it, you know, so it's still an issue that remains somewhat alive. So when we look at the case law, to be quite honest, until one case, and I will look at that South China Sea, the case law has not been very helpful, hasn't really provided guidance or clarity on what is the difference really between an island that is entitled to all the marine entitlements and a rock on that. And the very first case was the Jan-Mayen Conciliation, which is interesting, in 1981, while the convention had not yet been adopted, but they invoked Article 121, and without really saying why, Jan-Mayen Island was determined by the Conciliation Commission to be an island entitled to the all the maritime entitlements. So here's just the main cases, I would say. And really from all these cases, you know, and some have to do with sovereignty, some have to do whether the island should be included in the delimitation. They really provide us very little insight, other than in some cases saying, well, size is not an issue, or the geomorphological substance doesn't matter, whether it doesn't have to really be a rock, or can it be sand or something else. Or they just simply ignore it, such as in the maritime delimitation case with the Black Sea and Serpent Island, which of course in the Ukraine-Russia situation became quite famous, unfortunately. The court just ignored it because it didn't fall into the area that was relevant. But then came the South China Sea case, and of course we have here Professor Soons, who was part of the arbitral tribunal. And here we get for the first time very detailed analysis of what it means, what basically paragraph 3 of Article 121 means. It's lengthy. I am not going to summarize all of it, but in terms of some of the issues that may pertain to sea level rise, I selected. So first of all, it's important that they use an objective standard to assess the capacity of the feature to sustain human habitation or an economic life of its own. What's interesting though, it says actual habitation or economic activity at any particular point of time is not relevant, except to the extent that it indicates the capacity of the feature. The use of sustain indicates temporal and qualitative issues, but I think one point that is important is that first, human habitation can't be transient. So, for example, the question of fishermen using an offshore feature, you know, for fishing wouldn't suffice. But there has to be all the elements necessary, not just to keep people alive, but the conditions sufficient to have habitation, a livelihood, not merely to survive. So this is relevant for sea level rise as it becomes increasingly difficult for people to live on the islands. On the other hand, it's interesting too that even though the tribunal said, even though the feature may not currently be inhabited, doesn't mean that it is not uninhabitable. And it doesn't prove that it cannot sustain an economic life of its own. And it did give some importance to historical evidence showing that if in the past the feature was inhabited, this could be evidence that it is indeed capable of sustaining human habitation or an economic life of its own. What's really interesting though, and that is whether there is evidence that human habitation has been prevented or ended by forces that are separate from the intrinsic capacity of the features, such as war, pollution, and environmental harm that lead to depopulation? And can we add to this sea level rise as well? So to date, it still remains as the only case that has given quite a bit of guidance, but it's won award. And then, as we all know, China did not appear in this. And it has been somewhat of a controversial decision, but nevertheless, it does provide, I think, some important guidance concerning paragraph 3. Next, I wanted to also look at archipelagos. This is another one of those ticking time bombs as well for sea level rise and the potential of loss of very expansive maritime areas and maritime entitlements. So Article 47, and really is a very complicated formula, but what's important is that an archipelagic state may draw on straight archipelagic baselines joining the outermost points of the outermost islands and drying reefs. Well, some of these can be quite susceptible to inundation from sea level rise. And once they do that, they have to meet this very complicated formula. And the issue is quite simple. What if one of those outer points or outermost islands or drying reefs disappears? And that formula, the computation, now no longer can be reached. That means that the archipelagic baseline, if it were ambulatory and had to be lost, could result in a loss of significant the archipelagic waters and all the entitlements, rights, and obligations that go with those. And we have, and this is from the ILA report, that 22 states claim archipelagic status, and at least 7 of these have used small islands and potentially vulnerable island features as base points. And in fact, so for example, Indonesia is one of the archipelagic states, and they are vulnerable as well. We have the Maldives, who has already expressed its concern. But this is interesting. I took this from a very recent article from last year by David Freestone and Clive Schofield, who did a detailed examination of archipelagics. And they gave, for example, the of Jamaica. And Jamaica is vulnerable, and it could be in a situation where it would not be able to meet the minimum 1-to-1 ratio standard of land to water. Or a second scenario is that they could still maintain their archipelagic baseline, but if they change their base point, they could still lose close to 4,000 square kilometers. So the problem is the Law of the Sea Convention doesn't say anything about loss of rights. And I think this is what we're also grappling with when we're talking about baselines for the ambulatory, but it's a question of preservation of rights. Well, what happens? Do you lose them? We don't know. The Law of the Sea Convention doesn't explain it because sea level rise was not an issue then, so it's not surprising. So obviously preservation measures are important. And may I ask if I've gone over my time or not? Am I doing okay? Okay. So the question then is, preservation, how do we preserve the rights? Well, we know that under international law, there's plenty of state practice of artificial preservation, land reclamation, dikes. Also, even though low tide elevations cannot be used to draw straight baselines or archipelagic baselines, if there is a lighthouse or another a similar installation which is permanently above sea level, then it can be used. So it's another method of, an artificial preservation, we could say, building. One thing that is also coming up is the use of artificial islands. And there are actually companies that have been formed making rather very sophisticated floating cities. And under the Law of the Sea Convention, interestingly, we don't have a definition of an artificial island. So when the only thing that the convention provides for is, of course, within the context of the exclusive economic zone and continental shelf, that artificial islands, installations, and structures do not have the status of islands, meaning they don't have marine entitlements, of course. But what is there a point? I think this is a question that we're asking the Commission as well. Is there a point where the naturally formed island can become more artificial than natural? Is there such a criteria? There's nothing there. There's very little practice on this, except that we know there's plenty of practice on states doing artificial means to preserve their coastlines, and they could do it for baselines, except it's also very expensive. But we have here the Maldives, Hulhumali. And the Maldives have embarked upon a major project to basically create a new capital city. But it's purely artificial. But what if building an artificial city on top of, we know under the South China Sea case that the arbitral tribunal made very clear that you cannot use artificial means, technology to turn a rock into an island. But how much can you use to maintain the island status? I mean, if this were built on top of, let's say, an island that had pretty well almost disappeared, for example. So these are just some questions to ask. State practice. I mean, it's quite clear. Singapore, they foresee investing $100 billion or more to preserve Singapore from sinking. But not all states have this capacity, the finance, the wherewithal to do this, and not as well as environmental considerations as well. But anyway, this is the South China Sea case. So in the Commission, we analyzed these issues. So I just kind of gave you an overview. We made some preliminary observations because our work right now is really a mapping of the issues. We are not doing codification. States are very concerned that the Commission not go in, challenge in any way the integrity of the convention. So we're just looking at, mapping the issues. But it's very clear that because of sea level rise, if an island that currently lawfully enjoys the full panoply of maritime entitlements, the reclassification to a rock would result in significant maritime territory loss, loss of entitlements, and we have to understand that this is not just simply space, but economic loss as well, very significant. And when we look at state practice, to be quite honest, the state practice is, I haven't gone into it, some of it's controversial when we talk about islands and rocks, but states have different views on that. We know that there's a lot of conflict. So state practice really doesn't provide any guidance, and that's why what the emerging state practice about baselines, I'm not sure we're going to have it for the islands unless there is this other instrument that we're able to include that as well. For paragraph 3. And it also is related to the issue, of course, loss of statehood, but we're not looking at that. Anyway, so these are some of the observations we made, but again, most important is that the Law of the Sea Convention is silent on this. So we really do have to come up with some, really do have to come up with some responses to this. And so I look forward to your comments, and because this is still a work in progress, and I think it is, as Professor Soon's state comments in the 6th Committee are very encouraging. I think we see a very constructive attitude. So hopefully we will be able to respond to these truly challenging, but also for many states, existential issues as well. Thank you.
Thank you, Professor, for presenting the audience with another set of very challenging questions and issues. Of course, we have about, I hope that we can extend our session a little bit because we lost about 10-15 minutes, so we can go a little bit over 5 p.m. And with the permission of the organizers. But allow me now to, without wasting too much time, to introduce our discussants. Professor Lee Keun-Kwan, who is a professor of law at the School of Law in the Seoul National University. And I'm not going to go through the whole CV, but he is due to serve as one of the members of the International Law Commission as from next year. And his research interests include the history and theory of international law, state recognition and succession, and the law of the sea. The other discussant is also Professor Lee Ki-byum from Yonsei University Law School. He's teaching public international law. And of course, his research interests include maritime boundary delimitation, international dispute settlement, territorial issues, and international institutional law. Well, Professor Lee, on my right, you have the floor.
Okay. Thank you. Thank you, Mr. Yarish. Well, good afternoon, everyone. And first of all, let me express my sincere thanks to the organizers of this conference. Well, this conference is celebrating the 40th anniversary of the adoption of the UNCLOS, but at the same time, you can see another double-digit number, that is GORC at 10. So I think that's another cause for celebration. And Nilufer, Professor Oral, he mentioned that we have some snow here, but in Korea, I don't know, probably you have the same ideas in other cultures or civilizations, but in the Korean language, we have an expression called seosol, literally translated auspicious snow. So snow as a good omen, as a good sign. So I'm sure that this is a welcoming sign from maybe above. So even though we have the coldest weather of this year, but let me extend the warmest welcome to all of you, especially for those who have come all the way from abroad. Well, and I feel very privileged to be part of this session, and as was kindly remarked by Professor Oral, well, we have Professor Son's here and Professor Oral herself, and who are the experts on this question. And as you have noticed from the intervention shortly made by our chairperson, he has quite tremendous expertise on this question. So we are all privileged to think together and learn a great deal on this subject of high topicality and importance. And so let me but at the same time, as you have seen from Professor Son's presentation, in his presentation he raised a number of questions, a list of questions, and I think we can just single out, pick just one question, and we can devote at least a full day's discussion to those issues. So within the 7-minute time limit, it'll be almost impossible to do justice to all these important questions. So I'll just limit myself to one question. Well, what fascinated me about these wonderful presentations was that, among others, the interface between treaty law, especially UNCLOS, and customary international law. So I'll limit myself to the discussion of that question. In particular, Article 5 of UNCLOS. And before doing that, let me just mention that, as was kindly introduced by our chairperson, I'll have another privilege to work as a member of the ILC from next year, from January. And as you know, Professor Oral is one of the 5 core chairs of a study group on the sea level rise in relation to international law. And there, you can see that through the exercise, through the work of the ILC, we can have an opportunity to learn more about state practice. And so I think, I'm sure that the ILC will make further contribution in that regard. Right, so let me go back to my point of discussion, a main point of discussion. Well, that is, again, how to situate or how to characterize our question within the framework of UNCLOS. Well, my discussion is mainly based on the abstracts submitted by our two speakers. So if you have read these excellent abstracts, there you can see concerning in relation to the question of the interface between UNCLOS and the customary international law. Or there you can see some subtle but at the same time important differences between these two abstracts. For instance, Professor Oral, she mentions the lacunae. She mentions the lacunae in the UNCLOS. And on the other hand, Professor Sons, he talks about an interpretation. I think he talks about, a changed interpretation of Article 5 of UNCLOS or a modification of Article 5 UNCLOS. So the question is whether this important question of sea level rise, or maybe more specifically, the consequences arising from sea level rise, are they already covered by the ILC? I'm sorry, in UNCLOS, or is there a lacuna, or maybe are there lacunae waiting to be filled up? And in that connection, maybe one can consider the rather well-known taxonomy in connection with equity. So there is equity infra legem, equity praeter legem, equity contra legem. So if the international community adopts the new practice, which was expertly introduced to us by Professor Sons, the last year there was declaration by the Pacific Island Forum states, and very recent position expressed by the U.S. government on this question. So the new practice is accepted as good law, as it were. Then how can you interpret this, let's say, embrace, as it were, of this new practice into international law? So is it is an exercise infra legem? So is an interpretation, changed interpretation, or maybe evaluative interpretation of the relevant provision of the UNCLOS, or is it a filling up the lacunae left by the UNCLOS, or maybe the drafters of UNCLOS, or is it a exercise contra legem? And our chairperson, Mr. Yarashi, mentioned the fundamental principle of land dominates the sea. So, to that extent, is it kind of an exercise in the nature of contra legem? So I think maybe, in my opinion, in my humble opinion, the introduction of this taxonomy of distinctions between infra legem and praeter legem and contra legem could be instrumental in clarifying the question and trying to answer some of these difficult questions. And that was my comment. And I have very short questions to each speaker. First of all, let me address this question to Professor Oral. Well, in Professor Sons, in his abstract, in the last paragraph of his abstract, he is thinking out aloud in the options that's available to the international community. So he's saying that, formal amendment to the UNCLOS or the adoption of separate legally binding agreement to this effect is, according to him, is unrealistic. And he's thinking out aloud about the advisability or otherwise of adopting a UN resolution on this question. So I wonder whether, because you are working as a co-chair of the study group, as a study group, Do you have any reflections on this question? And to Professor Sons, in a way, I'm elaborating on the question you have already raised. So again, how to characterize the incorporation or embrace of the new practice into international law, and in that connection, you say that Article 5 it reflects understanding, and especially the ambulatory theory. So you say that until very recently, the generally accepted interpretation of Article 5 would be basically the so-called ambulatory theory. And so I wonder how you evaluate the normative potency or maybe density of this understanding of Article 5. And those are my questions to our speakers. And once again, thank you very much for your wonderful presentations.
Thank you, Professor. And I hope that Professor Sons has taken good note of these questions. So before I give you the floor to Professor Oral and Professor Sun, let me allow the other discussant, Professor Lee Ki-beom, to make his intervention. Over to you.
Yeah, thank you very much. Hello, good afternoon. I'm Ki-beom Lee. And first of all, I'm highly honored to be here. So I would like to express my big thanks to the Ministry of Oceans and Fisheries and Korea Maritime Institute. Yeah, and I also I have also to thank two presenters for excellent presentations about sea level rise. Yeah. Just my comments could be just a little bit overlapped with Professor Lee Keun-kwan's comments. Yeah, but as you know, actually the title of the conference is UNCLOS at 40. Yeah, so we appreciate the adoption of the UNCLOS 40 years ago. Yeah, but the subtitle of the conference is, as you know, unsettled issues. Yeah, but I think that the matter of sea level rise would be one of the problems that cannot be settled unless we have customary international law or new multilateral treaty rather than the UNCLOS. Yeah, the reason for this is that, yeah, frankly, I think, frankly, we have no provisions in the UNCLOS governing the issue of sea level rise. Yeah, as Professor Sons pointed out, we could accept one possible interpretation, so-called the ambulatory theory in Article 5, Article 7, or Article 16 of the UNCLOS. Yeah, but however, yeah, I'm not sure whether the UNCLOS has adopted this theory, ambulatory theory. Yeah, because Article 5, I think Article 5 is just saying about low water line, as a normal baselines. Yeah, could it be, if the sea level rise, so baseline, normal, no low water line could be moved landward or seaward. Yeah, so as a consequence, the baseline, normal baseline, could move landward or seaward. So yeah, we could get the ambulatory theory from the interpretation of Article 5 or 7 and Article 16. Yeah, so the Professor Soon's just presentations are titled "The Significance of Recent State Practice on Baselines and Outer Limits of Maritime Journals." So I would like to focus on the word significance. Yeah, probably we have two options to understand the word significance. Yeah, firstly, just providing for one possible interpretation under the UNCLOS regarding the sea. Yeah, back to the importance of the word significance. Actually, firstly, the significance means providing for one possible interpretation under the UNCLOS regarding the sea level rise, and secondly, the changing the current law. Yeah, current customary international law, or doing against the current customary international law. But the fundamental question is whether or not there exists customary international law governing the sea level rise. And actually, this situation recalls me of the time in the late 1940s. Yeah, in the late 1940s, actually, following the Truman Proclamation, many states in American continent, many states, just made a declaration regarding the continental shelf. But we have to ask one question. In the late 1940s, whether or not we had the rules governing the regime of the continental shelf. Yeah. So, yeah, just the situation. The situation would be just like the situation in the 1940s. Yeah, but subject is totally different. Continental shelf and sea level rise. Yeah. Actually, but yeah, sea level rise is a new emerging important issue in international law. Yeah, I think most already knew, but 3 days ago, the ITROS received a request from the Commission of Small Island States on Climate Change and International Law to render an advisory opinion. Yeah, if I introduce that question for advisory opinion to you, yeah, what are the from the Commission of Small Island States on Climate Change and International Law, 3 days ago, what are the specific obligations of state parties to the UNCLOS, including under Part 12, especially B, to protect and preserve the marine environment in relation to climate change impacts, including ocean warming and sea level rise and ocean acidification. Actually, sea level rise is emerging and an important issue in international law. And so, Professor Soons has interpreted the recent state practice in relation to sea level rise, especially island states. Professor Soons mentioned 3 options or 3 means by concluding maritime boundary agreements, and secondly by redefining in legislation their baselines and the outer limits of their maritime zones, and thirdly by taking the position that these baselines and limits will remain in place notwithstanding any future changes to the low water lines, blah, blah. So, but you already know, but last year we met one important declaration called the Declaration on Preserving Maritime Zones in the face of climate change related sea level rise from some island states. They declared that once having, in accordance with the UNCLOS, established and notified, they intend to maintain these zones without any reduction. So, actually, we have to very carefully analyze this recent practice, state practice, and circumstances. Actually, as I said, the situation is very, very like the situation in the late 1940s. So, as I said, 2 options. Just the recent state practice is providing for one possible interpretation under the framework of the UNCLOS, or just doing against the current customary international law. And secondly, I have to go to just Professor Oral's presentation. Actually very interesting, especially devolution of an island into law. That is a very, very interesting question. But if we accept the logics from the 2016 arbitral awards in the South China Sea, devolution is also a situation under a natural condition. So that means under just in the context of a natural condition, devolution would be possible. And we have to differentiate artificial fortification and artificial activities. So artificial fortification is to maintain just the legal status of a feature, but artificial activities is to elevate a log to an island. I think, let me stop, and then if I have some time, I ask a question again. Thank you very much.
Thank you very much, Professor. And now, perhaps we should start by allowing Professor Soons and Professor Oral to answer the first questions posed by the discussants, and then we'll move over to other questions from the floor. Over to you, Professor.
Thank you. I'll try to be brief, but I'm tempted to, and perhaps I should do that, to make a few sort of general observations about this topic. The questions to me from both Professor Lee the first and Professor Lee the second overlap to some extent. So I'll try to combine them. But before that, I would like to make the following observation. We are talking about a societal problem, sea level rise, that has specific consequences. They vary from state to state, but to a large extent they apply generally, but to some states they apply more intensively. It seems to me that there is that the policy objective that you see getting accepted, I think generally, is that the potential loss of entitlements should be prevented. Of course, we have the technological means to do that. These are unobjectionable in principle, I would say, but costly and not always feasible. So apart from that, and some states will certainly do that, other states will not be able to do that. But to make the states that are not able to use all this technology in a disadvantaged position, I think is unacceptable. And I think this is, at least that is my reading of the debate so far, also government's sixth committee, is generally accepted that that should not be the case. So the world is in search for a solution for a problem. And the problem is caused, and then I come to one of the questions about the ambulatory baseline. When you look at the state practice until very recently, and for some states still current, is that the normal baseline as charted, as put in the charts, and when there's a new surveying and the charts are amended, of course the charts are primarily made for navigational safety, but they serve this purpose of having the indication of the normal baseline, low waterline, normal baseline, that always, until very recently, this has been, it has been accepted and done in practice by all states involved that are confronted with these changes in their coastlines to adapt their normal baseline. That to me means that the ambulatory theory interpretation of Article 5 is indeed the current law. But since we are aware of the problem it creates, of course, states are thinking, and not only states, but many people are thinking about what to do with that. And now we come to what are we observing here? How is this normative change? As lawyers, what do we see happening, or what could happen? Now, one step back. If indeed there would be in a couple of years a UN General Assembly a resolution adopted unanimously stating that these baselines can be fixed, and if they are notified to the Secretary General based on the current correct interpretation of the location of the waterline and straight baselines, etc., that they remain in eternity, if that is in the General Assembly resolution, I think the whole discussion among lawyers about what exactly is sort of the normative basis becomes perhaps less important, because then everybody simply, all states will adopt this practice and nobody will challenge. So it's a fact. But then, back to the law. I think it's then interesting to start with the idea about the development of customary international law. There has always been rules on baselines and custom. I think almost all states accept that the current provisions in the Law of the Sea Convention on baselines are in essence reflective of general customary international law. So at the moment I think you can say they coincide. Now, customary international law is, by its very nature, subject to change. The practice and opinio juris together can, and this can go sometimes very quickly. There are examples, because the continental shelf was an example. In the few years after 1945, customary international law changed on the continental shelf. Even the exclusive economic zone, fisheries zones and exclusive economic zone can change. customary international law can change treaty law. There are clear examples of where the general provision in a treaty has been superseded by a new rule of customary international law. That's one option. I didn't mention it in my paper, lack of time, but one option is that we construe at a certain moment that there's a new general rule of customary international law to this effect, and that it supersedes some provisions of the Law of the Sea Convention. Personally, it's an option, but personally I think that's not necessary, since the ambulatory baseline are all in fact based on interpretation as reflected in practice of the current provisions. It is also possible to conclude that by changing the practice, you demonstrate a changed interpretation. And if that is accepted, that would be the law. Of course, the best thing that could happen would be a formal, legally binding agreement. That is not a realistic option. General Assembly resolution comes very close. Of course, it's not legally binding, but etc. can have all these consequences. And finally, if I may, one word about the principle, as it is referred to, the land dominates the sea. This principle, so-called principle, has become a principle because the International Court of Justice at one moment referred to it as a principle. Well, this happens more often. That does not mean that from that moment on there is a new principle of general international law, the land dominates the sea. What the International Court tried to say at that moment was that on the basis of the then current international law, entitlements are to be measured from land. Now, international law can change. The principle of the land dominates the sea cannot prevent any change in the law. It's reflective of the status of the law at a certain moment, and the status of the law can change.
Yeah, thank you. I have to say it's such a fascinating issue, and one with very real consequences. And so I agree with almost everything Professor Soon said. I'll say one thing I may disagree a little bit. But this issue, so where do I start? The question to me was, Professor Soons had put forth some options in terms of that. But let me also make some comments. What's very interesting in the Commission, and this is, I think, where we see a lot of complementarity between the work of the ILA and the work of the Commission. The ILA was very instrumental in actually putting forth this notion of preservation. But however, it's through the Commission, because of our role as a subsidiary organ of the UNGA and this relationship with states through the Sixth Committee, when we presented our first issues paper, the reactions that came out. And I could not agree more that I also feel that we're in that moment where we're seeing law in the making. And it's, right now we're seeing the emergence of possible state practice, not yet opinio juris. And where I am going to disagree a little bit, this is my own personal view, it does not reflect the Commission at all, but I'm not quite sure that the ambulatory view baseline is law, because the reason I say that is that one of the, what we're trying to do in the Commission is really get practice information from states. And there are states who do, you know, maybe it's every 30 years, but do have law concerning resurveying and updating. But I'm not sure that's really that universal. There are plenty of states that do not have a position on this, actually, particularly, for example, Southeast Asia. So I'm not sure if it's at the point where we can say, I agree it's an interpretation, but I'm not quite sure that I agree that it's the law. But anyway, we'll put that aside because it's changing. It's changing. And I really do think that my view is that international law should also be a tool of adaptation. And one of the adaptation is actually formulating responses. Now, amending the convention is not realistic. Totally agree on that, and I don't think that's going to happen. Having another agreement, that takes so much time. The issue of a UN resolution is interesting, but I think it's still early myself because states are in a position where so far we have a very positive momentum. My concern would be that once you start putting it to trying to get consensus, suddenly you may find problems arise. So I would wait on that and give. The work of the commission, we still have another 2 years, of course, and see. And part of what we will be doing, of course, was making some conclusions and recommendations. The advisory opinion, there's definitely a role for that as well. And I have to say that I'm actually part of the legal committee on the COSIS, so I do have a slight interest in that. But there's definitely room because, again, it is lacunae. We all accept the convention could not have possibly foreseen everything, and certainly not sea level rise. There are legal questions. So it's a question of distinguishing those that let's leave to state practice. We can see that happening, and those that are really, interpreting and understanding the convention from a purely legal view. So there's a role for that as well. And I don't want to go on and on. It's an issue that evokes a great deal of passion and interest. So I'll stop here.
Thank you very much, Professor. Indeed, what the Commission is partially trying to do in this, facing this sea level rise, is going back and trying to fix a very static model of the Convention, which was imported from the 50s, when there was little understanding that the planet is actually a dynamic, very dynamic environment. The tectonic plates theory was coming only later on in the 60s and 70s. So, in fact, the model of the convention is very, very static, while the planet is, in fact, a very dynamic creature. Professor Ong, I think, has a question. David, microphone, and then we have Susan. No, well, ladies first. Ladies first. Okay, Susan, over to you.
Hi, thank you so much. I'll be very brief. I was wondering about the problem with the land dominates the sea. I think if we're talking about baselines legally established, well, we did use coastal geography to establish the limits that the baselines that are going to be frozen or deterred. So I don't see that as a huge problem. Professor Soons, and I think it goes to Professor Oral's last comments. I'm encouraged that you see such a momentum. I wanted this issue about lawfully established. And Professor Soons mentioned, might there be a vetting process? And this is to your point, Nilüfer. I think if you start going down that road, I can imagine some states not too happy about that. And so I just wondered, where does that feature in what you're seeing in emerging? Like, I wasn't aware that the Pacific Island states would have been happy to have their baselines vetted. So it's just that question, where was that just something that, is it our, the authors of excessive maritime claims around the world that are pushing this interpretation, which might be unfair, but just curious where that features in what's going on at the moment?
Let's actually take both questions, and then we'll. That will be probably all we can manage in the remaining time that we have. So, please, over to you, David.
Thank you very much, Chair, for giving me the floor again. I realize I might be hogging the question time. Just a very quick question to both panelists, please. But actually, Nilüfer may have already preempted me because I was listening carefully, but maybe I missed the point as to whether one way of ensuring a legally, not legally binding, but certainly a legal declaration is to ask for an advisory opinion from the ICJ on this issue to build on. And secondly, and this is more tongue-in-cheek, in order to try to square the circle where you have a situation where there seems to be acceptance that baselines might be rendered, if I may, not ambulatory, but intractable, permanent, but at the same time, the island itself may be disappearing, therefore the territory itself may be becoming submerged. I wonder whether we can go back one big step to the origins for the concept of statehood, which talks about control over territory, but doesn't actually say whether the territory must be above land. So it may be control over submerged territory. The territory is still there. It's just submerged. Thank you.
Over to you. I don't know who wishes to start. Professor Soons? Okay.
Thank you. I think the question to me was from David, whether or not this would be suitable to ask an advisory opinion from the ICJ on this issue. I have doubts if that would be helpful. And the same applies to an advisory opinion from ITLOS. The advisory questions, the two questions that are now before ITLOS, are phrased in such general terms that I almost can't see how ITLOS can really give an answer unless it would be a huge answer or a short answer, but in very general terms. The questions are not specific. And I think the more specific they would have been, the more, the better ITLOS or ICJ would be equipped. But to, a specific advisory opinion on these baselines and entitlements, why would that be helpful if the sort of in fact, the answer has to come from the states. What new interpretation, what new law they wish, and there seems to be a converging view there. I agree with the statements made also by Professor Oral that it's well, you need more clarity. That's what I also said. In the next few years, it would be very helpful if some of these questions that are still lingering would be defined more precisely, so that the state practice can move in that direction. And then perhaps in a number of years there would be it would be possible to have a UN General Assembly resolution. The second question about islands disappearing and statehood, that is something that the ILC is looking at, the ILA is also looking at, but it was not the topic that I had to deal with, so I refrain from, I mean, there are so many difficult questions here, I refrain from commenting on that.
Maybe you'll answer that question. Over to you.
Yeah, I think Suzanne had asked a specific question on baselines and vetting. So first of all, when we look at this is a very lengthy and expensive process. That's one thing. One thing we're looking at right now at the Commission as well is the whole issue of hydrographic services, the use of charts, the preparation of charts. But the truth of the matter is, in reality, not all states have the capacity to be able to do the necessary surveying of their coastline. It's far more complicated. The Pacific Island states, they were able to do it because they got support from Australia and New Zealand, I believe. So the point I also make is that if, it's again creating a double standard. If you say that there's a certain rule, and when we look at ambulatory as being the rule, it presumes that there's an obligation that goes with it. If we're just saying ambulatory, fine. But if you're saying ambulatory plus the obligation to update, now I have a problem with that, because it's essentially putting poor states, or those states who do not have the capacity at a disadvantage. But also, how can you discount them from trying to determine whether there's a law or not, because they're part of it as well as a general practice. So that's why. And so we're doing it at the Commission. I know Doalis has been helpful for us. We did a survey of treaties, looking at the notifications that's been given, trying to really understand what is the state practice, asking states, what do you do exactly? So it's very interesting. So, And on the advisory opinion, I think there's a place for advisory opinions, as I said, and where state practice is emerging, as it is with baselines and all this, it probably isn't really the right place. But I won't comment on Professor Fred's comments on the questions that have been posed, but I have to say it is an active period for advisory opinions. And I can only think that for international law, that should be positive, not negative. So I'll stop there.
The floor to Professor Konoe for his question. Just on the practice of the depository, which we have been performing from the entry into force of the convention, there was actually one case when a state tried to account for the ambulatory nature of the baselines, and the state came up with a huge database, and part of the statement of the national legislation, and I'm not going to say which state it was should their low tide elevation emerge and actually the existing straight line would be straddling the low tide elevation, then the baselines would be measured from the low tide elevation. And the depository, being very conservative, say, no, we cannot accept something which is so uncertain, because the whole issue of depositing, and of course the depository functions are very simple. There are two elements. It's registration and publicity. There is no review. We do not examine whether these deposited baselines are lawful. That means in conformity with the requirements with the convention, whether this is relating to the lengths, especially to the lengths, or whether this is the situation on the coast which calls for straight baselines. This is not the function of the depository, this kind of a thing. But in this case, we said no, because the idea of the depository, it's certainty, legal certainty. And ambulatory nature, which is sort of this dynamic, it can change tomorrow, that doesn't provide this legal certainty, then of course our functions, so we declined we didn't receive this deposit. And the state accepted our argumentation that we simply have to put in the public domain something which is very solid and stable in terms of either list of coordinates accompanied by the datum or a nautical chart indicating. And of course, there is no periodicity, so the depository doesn't require states to come back within a certain period of time. Actually, the only changes that were put forward by some depository states were linked to the recalculation of coordinates into different datums. So example would be Japan, for instance, which initially deposited information in the Japanese datum and later redeposited the same charts in the WGS 84. There have been some other cases like that. But now I would like to give the floor to another question. We have time because the dinner is at 6 p.m., so we can still take a couple of more minutes of our from our generous panelists. Over to you, Bjorn.
Thank you, moderator. And I was hesitating to make abuse of your kindness, but given that we have these experts on the panel, I'd like to share a comment on this particular issue, or topic, which is indeed fascinating. If we imagine that we have two states and with opposite coasts, and the distance between the baselines of both coasts is, let's say, 395 nautical miles, but because of the sea level rise, the distance between the coasts would be 420 nautical miles. If we would follow this procedure by vetting the maritime jurisdictions, it would obviously raise many questions, but one element which I believe perhaps was not mentioned today is that in this situation there would be areas which under normal situations would be contiguous zone or EEZ, but now would be internal waters, and which would inhibit the freedom of navigation significantly. And whereas State A and State B may agree to make amendments, hold on this agreement, I would think important also to have in mind Article 311, paragraph 3 of UNCLOS, which provides that states may make an agreement modifying or suspending provisions of UNCLOS, but on two conditions: that they are only applicable in their interrelations, and also that they are not incompatible with the UNCLOS itself. And it would also have to be notified under paragraph 4 of that provision. But if State A and State B would agree to, we will freeze our maritime zones. This would inhibit the rights of freedom of navigation in areas which, under the ordinary system, could be seen, for instance, as the situations may be, as contiguous zone, but given the agreements of the parties in question, it would be internal waters. So I would think that could raise many interesting questions, and I would perhaps also be keen to hear your views on that, and which finally would allow me to suggest that perhaps the best way for resolving this would be a determination of customary law by a court or tribunal, and which will obviously settle the matter. Thank you in advance for any considerations you may have.
Thank you. Perhaps this could be the last question, unless there are any pressing issues. Okay, then one more, and then we'll have to sum up, of course, after the panelists have an opportunity to respond. Over to you, Professor.
Yes, I'll try to be very brief. I just wanted to ask the two panelists if they see any challenges in having a new rule that is consistent with the understanding that the low water line and the normal baseline remains ambulatory when the low water line moves seaward. For example, in the case where you have like a volcanic eruption moving the baseline more seaward. This is actually a situation that we've had in Japan, and I'd like to hear your thoughts on this. Thank you very much.
Professor Soons, Professor Oral, over to you.
So on the question about the states, and my understanding is that they've come to the states who are A and B. I'm never good with hypotheticals. But A and B have come to an agreement. Is that and they want to change their agreement? Or is this the issue? They want to freeze their maritime. So one thing I want to say is interesting is that we actually did a survey of treaties. And to look at if any of these have actually included changing, adjustment in the future. And very, very, very few did. So in the sense that how you can interpret that, whether it's implicitly that those treaties are basically set. And another thing I just wanted to add, for example, even states, for example, the United States, they have very clear, their view is baselines are ambulatory, they resurvey their baselines, but that same rule doesn't apply to agreements. So so you see that the agreements, that those remain. And I think you will find that that's not uncommon. And in fact, in the statements that you see from the 6th committee, that's very clear as well. And we haven't raised the issue of legal stability, certainty, and predictability. But many of the states, agreements, pactus and servanda stays. And then you have the other issue I'm just going to add. What about adjudication? So the adjudicated maritime boundaries as well, or maritime delimitation, the same issue can be raised for that. So this raises the questions of res judicata. So now, if states want to agree, I see, the idea of that they've already have existing agreements, so I don't see a problem with that. But I think the caution is this, is that when we say it becomes internal waters, this is really a legal concept as well, and who's actually going to, at that point, my question is a realistic one. Are you going out and surveying, the coastlines and that? So I don't see that as really an issue. And on the expanding, that comes up. And my response to this is that what we're really looking at, the question of preservation of rights. And I think it's really important to make that distinction. Because that does come up as well. What about expansion? Yes, that can happen. But here the question is, when you have lawful entitlements, do we have the law that will preserve those? And this is, to me, they're two different scenarios entirely. So the general rule is one about preservation and that. Anyway, I'll stop. I think perhaps Professor Soons may have some better answers.
Definitely not. No, we can continue discussing this in more detail if necessary, or if you wish, later today or tomorrow. I agree. But I think what you mentioned, the example of new land or natural accretion, the effect on baselines, I think that is in line with the notion of the ambulatory baseline. But in view of the time, I think I'll refrain from expounding further because
Thank you so much, Professor Oral, Professor Soons. Thank you for very interesting inputs and responses, Professor Lee. Professor Lee, thank you very much for all your so very, very insightful comments and discussions, and thanks to the audience for this wonderful closure of today's first day of this conference. I think that it was very interesting, very engaging, also very thought-provoking. We have a lot of things to process in the days and for the International Law Commission and other scholars in the years to come on the issue of sea level rise, which is, in fact, as we know, for many nations an existential problem, which makes it particularly challenging and also particularly as human beings, of course, we all sympathize with those who are on the verge of losing their livelihoods, their homes, their states, given to the anthropologic effects of introduction of greenhouse gases into the atmosphere and global climate change. So the whole humankind is facing as very serious issues for the future, and hopefully you'll find the strength to engage in meaningful international cooperation to address these challenges. And with that, I would like to thank you, and then a round of applause for all our participants. Thank you.
Thank you. Now it has come to the end of our program for today. I extend my sincere thanks to all participants. And here's some quick announcement to make about dinner tonight and tomorrow's session and excursion programs. The dinner will be served at the Uccello, the restaurant on the first floor, where we have breakfast this morning, from 6 p.m. And we will continue the session 4 here again tomorrow morning at 9:30, 9:30. And about excursion, we have 2 excursion programs after tomorrow's session. In the Friday afternoon, we will visit the Lotte World Tower, the world's 5th tallest building with 123 floors. And you can see the panoramic, a full 360-degree view of Seoul and Gyeonggi province area. And on Saturday morning, we will visit Gyeongbokgung Palace. And then, if time allows, we will visit Bukchon, one of the traditional villages in Seoul, and Insadong, the shopping street. So if you want to participate in this excursion program, please let our staff, Miss Kim Ji-hye, over there, know by tomorrow morning. That's all. Thank you. See you later. Thank you.
we can talk more, yeah, definitely.
Ambulatory, I don't like the word, but it's generally accepted term now, so it's a nice shorthand for this idea. In my view, it does not include, maybe I can have different interpretations of what the ambulatory is. In my view, certainly there is not an obligation on the state to permanently sort of be aware and update it. I don't think that is I mean, the many people who would say that, I don't know them. I haven't seen any literature supporting that interpretation, but maybe it's adult or something. What is it? And I think this is really, under very reasonably accepted, although many places are not, because it's hydrographic. The people who do this work are not the people who are interested generally in sort of specific ideas about what they are obliged to do in the law, in ISO, and they are charged. What they do generally is, and I think is when they have a survey necessary, so when they incorporate the new findings about the location of the water line, they issue a chart, and that is a chart that they directly use for the calculation of the limits. And nowadays, there's almost charts you already see it. And it was thinking of changes in 10 years with the electronic chart where everything is there. But it depends very much on the type of code that you have. For Norway, this is all very, very important. Their baseline impact are fixed naturally. For the Netherlands, Denmark, Germany, UK, those are the countries in Northwestern Europe, which always have a structure of every so many years surveys of the visibility of all kinds of investigations. They issue new charts, and it will lead to sometimes small, sometimes bigger changes in their normal baseline, and it's reflected in the chart, in the algorithm. So this general understanding, I think we can only interpret this as the interpretation that this is the way to calculate the maximum limits of your cell. You use that baseline, that changes. It changes also with extensions of the land surface.